ಬೆಂಚ್ ಬೇರೆ ಬೆಂಚ್ ಕೊಟ್ಟು ಅಷ್ಟೇ ಮೆನ್ಷನ್
ಮೆಮೊ ಯಾಕೆ ಲೇಟ್ ಆಗಿ ಹೋಗುತ್ತೆ
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಬೇರೆ ಆದ್ರೂ ಮೆನ್ಷನ್
So pending matter.
ಮೋಟಾರ್ ವೆಹಿಕಲ್
Pending matter.
ಯಾವತ್ತು ಡಿಸೈಡ್ ಆಗುತ್ತೆ ಸರ್ ಬೇರೆ ಕೋರ್ಟಲ್ಲಿ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ ಏನೂ ಆಗಿಲ್ಲ ಡಿಸೈಡ್ ಆಗಿಲ್ಲ ಇಲ್ಲ
ಅದು ನೈತಿಕಿದೆ.
Yes.
My lord, my only urgency is demolition order. It has been noticed for tomorrow. It is my own property. Maybe have it today, my lord, 2:30.
Who's the respondent?
BDA, my lords. We have served a copy also.
Yes, Krishna. Huh? ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ ಆಯ್ತು ಅವ್ರು ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರೆ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ಗಿವ್ ಹಿಮ್ ಅ ಕಾಪಿ
I'll do it, please.
2:30.
2:30, please.
Fresh matters, please give.
The lordship kindly Miller, one matter, motor vehicle matter,
Give it.
urgent tomorrow,
Give it. Give it.
give it tomorrow.
One matter for tomorrow.
Give it.
A memo shall
This
take
is an old matter, my lords, wherein notice was issued
Wherever respondent is BDA or government, give one extra copy where matters are moved for tomorrow.
My lords, this is an old matter, my lords, wherein notice was issued and was directed to be listed today, my lords. It's covered by a lordship's judgment,
Give it. Give it.
but the matter has not come up, my lords. For tomorrow,
Not tomorrow. Tomorrow special roster. Let us see. But the date will be given.
my lords, similar matter is listed today, my lords. Maybe on Monday, my
It's okay.
lords.
If not today, tomorrow it will be disposed.
Grateful, my lord.
You're changing my roster, is it? Same roster may come, let us see.
My lords, Friday.
Matter is pending before the special court, my lords, for the NPS.
Hmm.
My lords, the issue, my lords, is that the FIR has been instituted when the.
Give it now.
For tomorrow, my lords.
It will have it. Yes.
application number 80
Just wait.
adjournments list 1 page number 1
Give your memos. Give your memos.
page number
Lordship,
2
there's an urgency. The petition is already disposed of, but I need some clarification regarding the interim order. I think I've mentioned.
You have to file an IAS.
I've already filed an IA, Lordship, and then I put the memo. Kindly list it for tomorrow, Your Lordship.
You have filed an IA, is it?
Yes, Your Lordship. I've already filed an IA. With the counter, I've already filed it.
my lord list number
ನಾಳೆಗೆ ಹಾಕ್ಬಿಡಿ ಸರ್.
Madam, ಇದು ನಾಳೆ
Fresh matter. Give it. Give it, please.
my lord adjournments
Two matters were, I have already moved. IF for vacating is filed. The road construction is has been solved. The interim order required to be vacated. And compensation is already paid, not in one case. urgency is this mode, the road is.
My lord,
My lord, list number 1, serial number 8.
Just wait, just.
no, it's a pending matter.
give it.
Matter was listed like on 16/9/2025, and it's still yet to be come on the board.
Give it. Fresh matter.
Yeah, the petitioner intends to withdraw the petition due to some technical errors. So we need to file a fresh
matters.
petition.
The fresh matter is still in. Yes.
Fresh
Give it.
matter.
Give it. Yeah, so what you have to-
Adjournments, list 1, page number 1, 1 to 5.
The last time the petitioner is serial number 5, requesting to give us some short date may be given.
Have informed the other side.
I'll inform the other side.
You must inform in advance. So now you just wait. Fifth
Just
matter
for
when it
admission,
reaches.
your lordship, the notice.
Correct, madam. It's the fifth matter. 5 minutes it will take. I will accommodate. you.
Page number 6, 14 to 20, page number 4, 21 to 28, page number 5, 29 to 38.
Your lordships, that serial number 37, your lordships, can we have it on Tuesday, your lordships, 3rd of March?
At request, the relist in same stage on. Yes. 30?
Deeply approached.
Matter was listed yesterday in court. I sought time in the court office and it was given on second. Listed by mistake.
Relist at request on second. Same stage.
ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅವರು ಅರ್ಜುನ್ ಆಯ್ತಾ ಅದು
Page number 6, 39 to 48, page number 7, 49 to 57, page number 8, 58 to 64, page number 9, 65 to 67, page number 10, 68 to 70, page number 11, 71 to 77, page number 12, 78 to 85.
I request 80 to be taken up at 2:30, my lords. 80 to be taken at 2:30. That is with respect to that Arekan.
Clarification.
Yes, my lords.
Interim order clarification.
Interim order, they not released my goods despite 2:30, my lord,
Right,
if it's
note
possible.
My lord,
Obliged, my lords.
my lord, serial number 81. The matter is pending before JMFC and the coercive steps are being taken for recovery, my lord. The police is harassing the petitioner and the wife. There is no interim protection, my lord. It might be taken up at 2:30, my lord.
Like March.
Page number 13, 86 to 91, page number 14, 92 to 95, page number 15, 96 to 99.
That's may make a mention in 96. I appear for the petitioner, 96, my lords. My lords, there's an order by this court, my lords, staying release of compensation. In spite of which, my lords, the BDA, the concerned official, has going ahead and issuing letters to the one of the respondent, my lords, to come and collect the compensation. I've moved an application, served it on the concerned respondent.
It's not correct, my lord. And now I get the information. They have, before issuance of the interim order, they have issued the entitlement certificate. Thereafter, they have not paid anything, anybody, any compensation is still with the medium.
We'll record that. We'll record that.
Yes, ma'am.
And then adjourn.
Yes, yes, ma'am, please.
Huh?
Please.
So at, immediately after fresh matters, I'll take it. I'll record that.
Let them record that,
Yes.
and my lords, serial number
Immediately after fresh matter.
95, my lords. It is a matter, my lords, which is under section 153C, which is covered by the coordinate benches as well as
Let us see. Covered, you'll have to wait.
Page number 15, 97 to 99, page number 16, 101.
My lords, 101, my lords. Day before yesterday, my lords have directed to list today in the fresh matter, the same stage. Matter pertains to regularization of unauthorized corruption. From 1964, she is taking position. Copy has been served to the Krishna, my lord, to the BDA. Same state has to be listed, my lord.
Krishna or Vasanta?
Vasanta, my lord. I'm sorry.
Okay, we'll have it after fresh matters list.
Grateful. I'm deeply obliged.
You must inform.
I will inform.
Page number 17, 102 to 104, page number 18, 105 to 108, page number 20, 109 to 111, page number 21, 112 to 115.
My lord, 115, my lord. In this matter, the vehicles have been confiscated and an appeal order was passed, and the petitioner has paid the penalty amount as per the order, and subsequently the revisional authority has passed a stay on the order. The vehicles still remain with the respondents. There's an urgency in this matter, my lord. My lordships may kindly have it at the end of the list or tomorrow in the fresh matters list, my lord. I've informed.
If you are ready to pay, same like if he's ready, it's okay, is it?
So what has happened, the first appellate authority has modified the order of penalty and reduced the penalty as levied by the proper officer. Then my lords, that order has been taken up on revision and the order has been stayed by the revisional authority.
Correct. On some terms we can say.
The stay has been.
They want to have it tomorrow, my lords, have it tomorrow.
List tomorrow in the fresh matters list.
Much obliged.
You have a look at what orders we are passing in other matters also.
Much obliged.
Page number 22, 118, list 2, serial number 1. List 3, serial number 1. List 1, fresh matter, serial number 1. Whether yes.
For the petitioner, Lordship, this petition has been filed challenging.
Yes.
This petition has been filed challenging the order passed by the RTO, my lords, rejecting my application for refund of road tax, Lordship. Similar matter is already at serial number 72, my lords. Both may be connected and heard together.
List along with serial number
72, my lords.
72. AG accepts notice for the
Appealable order, my lords. Appealable order. Appeal is provided under section 15 of the Motor Vehicles Act. They claim, my lords, that during the COVID period, my lords, they have to be exempted from payment of taxes. Representation has been given, and to that extent, my lords, an endorsement or order has been passed. Against that order, my lords, they have filed an appeal here. They can file an appeal before the Joint Commissioner appeals.
I have filed appeal also, my lords, and they have not considered the appeal.
Then
the appeal I produced it at Annexure F3, my lords. They have not considered that, my lords. In fact, my lords, the case is not of exemption; it is of refund. Exemption is if I'm not entitled, I'm not supposed to pay. I've already paid, my lords. During the COVID period, there was a notification released by the government saying that for the period, so I have produced the notification.
Where is that? Where is that?
My lords, page number 450, Annexure H, my lords.
Where is your?
It's a notification. Annexure.
Appeal.
Appeal is page number.
So what does it say? What is the notification?
My notification says that from period 24/03/20.
Just read.
Man, I'm a little slow in reading.
Kumar, read.
Well, there is an exemption to from. I'll read it. COVID-19 ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯವನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಲಾಕ್ಡೌನ್ ಮಾಡಿರುವುದರಿಂದ ಇದೊಂದು ವಿಶೇಷ ಪ್ರಕರಣವೆಂದು ಪರಿಗಣಿಸಿ ಕರ್ನಾಟಕ ಮೋಟಾರ್ ವಾಹನ ತೆರಿಗೆ ಕಾಯ್ದೆ 1957 ಕಾಲಂ 16(1) ಅನ್ವಯ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ರಾಜ್ಯದಲ್ಲಿ ನೋಂದಾಯಿಸಿರುವ ಹೊಸ ವಾಹನಗಳ ನೋಂದಣಿಗಳನ್ನು ಹೊರತುಪಡಿಸಿ ಎಲ್ಲಾ ಪ್ರಯಾಣಿಕರು ಮತ್ತು ಸರಕು ಸಾರಿಗೆ ವಾಹನಗಳು ಮೋಟಾರ್ ವಾಹನಗಳು ತೆರಿಗೆಯನ್ನು ದಿನಾಂಕ 24/3/2020 ರಿಂದ 23/5/2020 ವರೆಗೆ ಒಟ್ಟು 2 ತಿಂಗಳವರೆಗೆ ತೆರಿಗೆ ಪಾವತಿಯಿಂದ ವಿನಾಯಿತಿ ನೀಡಿ ಆದೇಶಿಸಲಾಗಿದೆ. I know that there was an exemption given, but that is only to insofar as ಪ್ರಯಾಣಿಕರು ಮತ್ತು ಸರಕು ಸಾರಿಗೆ ವಾಹನಗಳು. It has to be gone into
passenger and transport.
Passenger and transport. If they have filed an appeal before the appellate authority, let the appellate authority take a decision on that.
F3.
Annexure F1,
but how do you say this is undisputed fact? You demonstrate that yours falls within passenger and transport. Any permit or
what is the transaction of the?
What is the use of the vehicle?
It is commercial use, my lords. The commercial use. And my lords, the reason why they have rejected my application is saying that I have not provided any proof that the vehicle was in a stationary. It was not in use, my lords. I produced the parking yard tickets also, my lords, which shows that the vehicle was in stationary.
So correct. Now, if there is no dispute on facts, we can consider.
Yes.
One, you have to demonstrate it's a passenger and transport vehicle. Passenger means private, is it?
Private.
It's a Scania Volvo buses, my lord. Volvo
bus.
Volvo buses. What has happened? I was the financier. Borrower had defaulted on payment. I had repossessed these vehicles from the various travel agencies which had borrowed this vehicle.
You are the financer.
I'm the financer.
What is the date of seizing the vehicle?
My lords, I'll do one thing, my lords. I'll produce synopsis, my lords.
Correct. No, correct. What we want to know, if there's any point of adjudication, then you'll have to go and appeal. If here you show us
Yes, ma'am.
that it was not used, either it was whatever, you show us, if we are satisfied, we will pass.
Please, my lords.
My lords will get that order at page 448, my lords.
440.
448, the order passed by the regional transport officer. I'm not getting a copy of the appeal where they have filed it.
It's an annex to F3.
These are all filed before the transport commissioner, not before the appellate authority. My lords may kindly see, my lords, he's passed a detailed order. Can I just read it, my lords? An application is received from Volkswagen Finance Private Limited. It's a finance company. Mumbai on so and so regarding refund of tax in a sum of rupees so and so in respect of 12 vehicles belonging to them on the basis of directions of the Honorable High Court of Karnataka in W. The 12 vehicles in our office, vehicle so and so, in respect of which taxes were paid according to the pleadings, the registered owners have committed default in payment of finance advanced and the vehicles were seized by you from the declared place of garage, and the details of the seizure of vehicles and parking of vehicles was not
Just one
intimated.
minute. Now, this goes under the assumption that you have to show that it was not used during that period. But the notification is blank.
Yes, notification is plainly gives exemption for 2 months.
Yes.
That I cannot dispute.
But here the reasoning why he has rejected.
The reasoning, my lords, may kindly see,
Yes.
except for representation, no proof is enclosed, nor details are furnished about the parking of vehicles in question, and thereby your representation for refund of tax is not based on any proof. And in the absence of details, nothing could be inferred.
Now, in case you have
Produce the proof.
If he wants
Case
to
you
have
have
a
seized.
second occasion, a second opportunity before the very same officer, my lords, let him produce all those proof.
I've already produced it, my lords. In fact, 263 it's issued by the transport department. My lords may kindly see one of the receipts that acknowledgement that is given. 263, my lords. That's at volume 2, my lords. That is the verification of non-use. Vehicle is in stationary condition. This is certified by.
Now, for each of the vehicles.
Each of the vehicles, my lord.
You produce it, let us see. You make your list of.
Yes, my lord. I will produce.
AG accepts notice for the respondent. List along with serial number
72, man.
72 and list the matter in
Fresh matters.
preliminary hearing list on.
End of March.
Yes.
I'm grateful.
Serial number 2, M. Chandrachudha, B. Vachan.
E-auction conducted by the BD on 3/12/2012.
Yes, yes.
And I was the successful bidder on 18/12/2012.
Yes.
I have paid the entire amount.
Respondent is.
B. Vachan.
We'll take it up. We'll take it up as soon as he comes. In the as soon as this gets over fresh matters list only, I'll take it up.
Please.
You have told me 3 times the facts. I remember.
3, serial number 3, Veeresh R.
Let's say seek a passover. 3 and 4.
Passover.
Please. Great.
Serial number 4,
Serial number 4 also, my lords.
Passover.
3 and 4.
serial number 5, Raju, XY.
For the petitioner, your lordship, I request you to give us a small accommodation.
At request,
It can be taken up next week sometime.
relist in same stage on.
11. Serial number 6, PM Sudmalappa. Serial number 6,
Relist. Yes.
Sorry for the petitioner, my lords. My lords, we have complied with the office objection, but still it shows we have to comply with the office objection.
On merits, what?
If any is there, we'll do it in the course of the day.
Notice agide.
I appear for respondent number 2, please, my lord.
So why has it come in fresh matters list? What are your instructions?
My lord, service is yet to be completed, my lord. I have received only 1 copy. I am yet to send it to the board and seek instructions.
You serve one more list, one more copy.
Yes, my lords. Today we will serve the another copy.
Learned counsel. She, petitioner submits, office objection should be complied. A copy, additional set of copies to be served on counsel for R2. List week after next.
Much obliged.
7. Bhargav SV 7.
Lords, petitioner.
Just 1 minute. Previous matter, list in B group. List in B group. Yes.
And petitioner is carrying the works contract, my lord, business. And he filed returns for the financial period 2020 to 21, 21, and 22, my lord. Without serving notices on the petitioner, ex-parte order has been passed against the petitioner.
Yes. Order is that?
Just let the matter be remitted back to
Order
them.
is at which? Order is at which
Page 20,
annexure?
page 29, annexure C, my lords. My lords will get the observation at page 32, my lords. Or I'll go to the last paragraph at page 31.
Yes.
Has not filed an objection to DRC 1A. Hence, as per the provisions of 73(1), show cause notice in DRC 1 reference number was issued on so and so by electronically through GST portal. Further, the same was served through this office email to the mail ID lokeshpurti@gmail.com on 26/11/2024. In the said show cause notice, so and so and so. They don't file objections to that.
Shall we send it back?
This is the same email ID, my lords, that they have furnished at the time of registration.
On the portal? No notice on your portal. Yes, madam.
My lords, in paragraph number 8, they have mentioned that under section 75, subsection 4 to the taxable person by email and electronically through GST portal, ma'am.
Huh?
In page number 32, my lord.
Yes, yes.
Paragraph number 8. The taxable person has neither filed any objections on discharge with interest and penalty in response to the show cause notice issued. Further, 2 reminders were sent as per section 75, subsection 4 to the taxable person by email and electronically through GST portal by reference number so and so.
Why this is not sufficient? Is
Those are only reminders for personal hearing. They don't accept that there is a mistake on their part.
Just let one opportunity be given to the petitioner, my lord.
The petitioner.
10% of the tax amount.
10% of the tax demand.
My lord,
How much is it?
demand is
8,29,000.
So it will only
10%
be-
will be only around 82.
80%. 80,000, that would be subject to outcome. How much cost? M. Kumar's colleague would not have allowed you.
She'll be back. She'll be back.
The petitioner has challenged the order of adjudication at annexure C and C1.
you also, my lord.
2 orders are there.
2 orders.
As well as for the year 2021, as well as the orders of adjudication for the year 21-22 at annexure D. Petitioner has also sought for a restraint as regards the recovery proceedings are concerned. The contention of the petitioner that the orders of adjudication are passed without benefit of any stand of the respondent on merits. It is further submitted that the non-reply to the show cause notice is due to bona fide reasons and this court may set aside the order and remit the matter back for reconsideration, while affording an opportunity to the petitioner to take their stand on merits. Full stop. Peruse the order at Annexure C. Admittedly, order of adjudication is an ex parte order insofar as the authority has proceeded to decide the matter on the basis of material available with the authority, as petitioner had not made out any reply to the show cause notice. Full stop. Now, the order, however, narrates that there has been communication by way of email to the email ID mentioned through the GST portal. Full stop. It is noticed that the ground on which proceedings were initiated is on the premise of violation of section 9, section 12, section 15, section 37, 39 and 49. Full stop. The petitioner submits that if an opportunity is given, petitioner would be able to demonstrate and meet the grounds as made out in the show cause notice. Full stop. Perused the order at Annexure D. Even as regards the order at Annexure D, identical grounds as referred to at Annexure C constitute the grounds for proceedings having culminated in an order of adjudication. Petitioner would reiterate that they have material to demonstrate and meet each of the grounds as raised. Next. So the orders indicate that there has been communication of the notice through the GST portal. However, taking note of the consequences that would visit the petitioner if the orders are allowed to stand, and in light of the stand of the petitioner that they are in a position to meet the grounds made out in the show cause notice as referred to in the order of adjudication, would meet ends of justice by setting aside the orders at Annexure C and C1, D and D1.
C1 and D, my lord.
C1
D.
And D. Matters remitted to the stage of reply to the show cause notice with respect to both the financial years of 20-21, 21-22. Isn't it? 2 years.
2 years.
2 years.
The petitioner to make out a reply to the show cause notice. Do you have a copy of the show cause notice?
At Annexure B and
the petitioner to be present before the second respondent without fresh notice on. It's made clear if the petitioner remains absent on the date fixed, the indulgence granted by this court would stand revoked. Full stop. Petitioner to pay 10% of the tax demanded for each of the years referred to above. All contentions are kept open.
8.
Accordingly, petition is disposed of.
There is an attachment notice, my lords. Upon their depositing 10%, this notice has to be
Attachment at?
Attachment notice at page 43.
Annexure E, my lord.
Annexure?
E.
In light of the order of adjudication being set aside, the recovery proceedings automatically stand set aside, and the attachment as evidenced at Annexure E is required to be rescinded by the authorities by way of appropriate communication immediately on receipt of certified copy of the order. Yes.
8, serial number 8, Rojanes Babu. Serial
Paying
number
for the
8.
petition. My lords, we have filed the present petition challenging the initiation of the reassessment proceedings, my lords. In the present case, 148 is issued by the jurisdictional assessing officer as against the faceless assessing officer, my lords. And the assessment, page 61 of my writ, my lords, annexure A3, 148, my lords.
My lords, it's your faceless, my lords. You can go after April, my lords.
My lords, the assessment proceedings is going on currently and interim stay be.
In light of the contention that the notice at Annexure A3 is issued by the jurisdictional assessing officer.
Yes, my lords.
And authority ought to have resorted to issuance of notice under the faceless scheme. There would be stay of
Annexure A2 and A3, my lords.
Annexure A2 and A3. A3. Respondents to take their stand in writing within 3 weeks.
Much
9.
obliged, my lords.
Serial number 9.
My lord, this is a GST matter, my lord. The last occasion, my lord was inclined to pass an order and dispose of the matter. Came from
AG.
Yes. This is the case, my lord.
Why was it adjourned?
They wanted to seek instructions, my lord. My input tax credit has been blocked for making outward supplies, my lord. If I may have my lord's attention at Annexure A, page 32. Page 32, first paragraph, my lord.
Yes.
I'm reading from the second sentence, second line. This office is in receipt of inspection report referred above, stating that you, the petitioner, have made outward supplies to 1 million lights, who is my customer, my lord. Outward supplies to million lights and passed on the ITC without actual movement of goods, and then they go on to give how much is the amount, that is 2.34 crores. If I may have my lord's attention, next page, page 34. Last but one para. Since the supplier, the petitioner, has passed on ITC without actual movement of goods, and thus you have contravened provisions of section 16, read with rule 31, 36, 86A of the Act. Then, my lord, the last line of the next paragraph. They're asking me to show cause as to why, to the extent of 2.34 crores, my input tax credit should not be blocked. My input tax credit and million lights have no nexus. Million lights is my customer. Conceptually, my lord, when I make a supply, it gives rise to output tax, which I have discharged, and that is not in dispute. To the extent of 2.34 crores, I have already discharged the liability, tax liability. Input tax credit comes only when I make some purchases. That is in respect of million lights, who is my customer. What they do, they go block my input tax credit. It has nothing to do with million lights. They issue me this show cause notice, to which I filed a reply. I say that you cannot invoke 86A at all.
So Million Lights has claimed ITC wrongfully.
That is the allegation against them. He is one of my customers. There is no concept to block output tax. There is no provision. So they are trying to do something indirectly what they could not have done directly. There is no provision to block output tax, so they block my input tax credit. I have provided my representation, which they have ignored, and then they block to the extent of 2.34 crores. Now what they want to do, my lord, they are taking the tax that I have discharged, output tax that I have paid to the government, that is 2.34 crores, it is with them. They now want to block my input tax credit, it has nothing to do with million lights, to the extent of 2.34 crores. They are trying to enrich themselves by blocking here, taking the tax also. Now, if their allegation is that my outward supplies are illegal, let them refund my money. They can't sit on my tax, block here, keep that also, my lord. On the last occasion, my lord was inclined to pass an order and dispose of the matter.
Yes, sir. Yes, sir.
I request my lords to have it on Tuesday, my lords. There are some documents that I have to get from the central authorities also, because there is a report submitted by the central authorities with regard to the transactions of the petitioner. I would like to place that on record. My lords, I have it on Tuesday, my lord.
My lord, in any case, time may be given, my lord. In any case, they cannot invoke 16 or 86A. under provisions which they have blocked my ITC. My ITC and Million Lights have nothing to do with each other. Something very astronomical cannot be unearthed by that report. It has to do with Million Lights only. Million Lights, for a fact, is my customer.
So let us see, on Tuesday we'll consider.
My lord, maybe disposed of in Tuesday. Third occasion, my lord, is coming up for hearing.
Some clarification. On Tuesday we will dispose it of.
Yes,
We'll have it in the same stage.
same stage.
Release the matter in the same stage on Tuesday. Yes.
10, Satyanarayana TR.
According to petitioner minutes, the present matter pertains to the multiple orders passed for the same financial year, that is for 2021.
Yes, sir.
My lords, my lords may look into
Page?
My lords may look into page number 56, my lords. My lords, in that issues involved, para number 2, in that the first para number 1, short payment of tax in GSTR 3B when compared to GSTR 1. The same issue has been covered by the proceedings initiated by the respondent number 3. My lords may look into page number 52. My lords, in that first issue, short payment of tax in GSTR 3B when compared to GSTR 1. Lords, there are 3 intimation. DRC 01A has been issued, and show cause notice, 3 show cause notices have been issued, and also 3 adjudication orders has been issued.
What is this name, Kumar?
Please. Can I verify and get back on Tuesday, Millards? Can I verify and get back on Tuesday, Millards?
My lords.
Milord, this is.
Let us see. Let us see. Let us see.
Let's
You
kindly look into.
No, they want to verify. We'll have it on Tuesday. We'll pass orders.
No, Milord, this is very simple, Milord. Multiple officers have issued multiple this thing, Milord.
My lords, respondent number 3 has issued 2 orders and DRC 01A and 1. And also respondent number 4 has issued another one, DRC 01A 1 and also DRC 07, my lords.
Correct, but they want some clarification. Next date we'll dispose it of next day. You want it on Tuesday, is it?
Tuesday.
My lords, the matter may be remanded back by allotting one respondent.
We'll pass the same order on the next date. Release the matter in same stage on Tuesday.
My lords, another connected is there, my lords.
Relist along with
Today only it has listed.
serial number.
Serial number 24, 4954/26, my lords.
So we'll tag that with this matter.
Please.
Relist along with serial number 24.
11, Bhagavat P.
My lords, the matter has been listed for today, 24th, serial number 24.
That if both the same SSC, same point, we'll have it on Tuesday and dispose it of. Yes.
My lords, interim stay may be given, my lords, because property attachment has been, the respondents have given an intimation for property attachment and also.
Orders have been passed in the year January 2025.
My lords, an interim stay may be given, my lords.
Only a recovery, even assuming for the sake of arguments what they say is right. So they notice they can file a reply saying that petition is pending.
If something happens on Tuesday, we'll reverse it.
Obliged, my lords.
11, Bhagavat P. Government official.
Appealing for the petitioner in this matter also. So this is the matter of GST where goods have been confiscated by invoking section 130 of the GST Act also. So before getting into the merits of the case, I would like to tell some facts about this case. The officer have actually confiscated the goods for which he doesn't have the jurisdiction over the section 130 also. So the goods were actually transported from Chintamani Chikballapur to Andhra Pradesh on 3/12/2025 also. On 3/12/2025, the petitioners have also generated the e-way bill and also invoice also. So on 3/12/2025, the goods were inspected at the place of Chikballapur. At the time of inspection, the officer finds everything was in order. Even the e-way bill, invoice, everything was matching. But the thing is, like he is mentioning in the order that there is information got from the reliable sources. So he wants to make a physical verification of the goods, and he ordered for a physical verification, Your Lordship. So the physical verification was actually conducted on 9/12/2025, which is after 5 days from the date of confiscation.
Is there any statutory period within which?
There is no statute. There is actually a central government circular, but actually which the learned councils are telling that the state were not bounded by the respect to so and so circular. So just I'm making a submission before Your Lordship for a brief understanding of the facts. So what this officer did was like in MOV4, he finds if all the in the physical verification, he finds everything was in order. But what he also made was like he was writing to the joint commissioner for the physical verification of the principal place of business of the proprietor, which was not actually under the jurisdiction for invoking section 130, Your Lordship. So after going and inspecting the principal place of business, he is coming with a conclusion saying that I'm not functioning from my principal place of business. So for that reason, and the goods were also not loaded from my principal place of business. For that reason, he is confiscating the goods, Your Lordship. So Your Lordship, attention may be please want to.
Yes, what, Kumar, what is this matter?
I'll accept notice, my lords. First thing is, my lords, these are all appealable orders. The points that are raised in the other writ petitions with regard to shifting of from 129 to 130, I don't think that is a ground here. More grounds are more on facts. Appeal can be filed against this order under section 107, my lords.
Lordship, I will not take more than 5 minutes. Your Lordship attention may be drawn to section 68, Lordship. Section 68 of the CGST Act.
Yes.
Section 68(1), where it clearly where it clearly states that the details of the documents required to be carried under subsection 1 shall be validated in a manner as may be prescribed. So one is telling that the government may require the person in charge of the conveyance carrying any consignment of the goods value exceeding such amount as may be specified to carry with him such documents and such devices as may be prescribed. So section 68 actually provides made the assessee to carry only such documents, Your Lordship. So in the current case scenario, the petitioner have actually carried the document which were actually prescribed under section 68.
Where is that finding?
Your Lordship, findings is in Your Lordship, page number 68 of the writ petition, Your Lordship. And 70, they have made the clear findings. Page number 70, Your Lordship.
Yes. Yes.
So where they have actually mentioned the goods were not point number 1 in the top, Your Lordship. So what they have mentioned, the goods were not loaded or dispatched from the declared place of business. Then second, no scrap trading activity was being carried out at the registered premises, and documents were issued without actual supply from the declared places. So if I'm not functioning from my declared places, then obviously it results in cancellation of my GST registration, which is a separate proceedings, Your Lordship. So it doesn't have any direct correlation. And also section 130 clearly states that there should be an intention to evade the payment of tax where the officer can able to confiscate. Since I have declared all my output correctly, there cannot be an invocation of section 130. That is my humble submission before this honorable court. So this is a cause of adjudication. So cause of adjudication cannot be a reason for confiscating the goods under section 130, Your Lordship.
Page 68, my lords, may kindly see, my lords. The reasons why 130 has been invoked.
Yes.
Page 68, my lords. Para A to D. No actual business activity relating to trading of MS scrap was being carried out at the registered place of business of MBS traders. The proprietor so-and-so was engaged in automobile and electrical repair activities in the name and style of MBS electrical works situated at number so-and-so beside Indian Oil Fuel Station, Chitamai.
We can do one thing. If he is agreeable, we can send it back insofar as the request for release, if same terms they're ready to, it can be done.
Lordship,
They're totally a non-existing dealer and totally a non-existing dealer. At page 70, I'll just show my lords, at page 70, with regard to the more reasoning why 130 has been invoked and the mens rea and the intent to evade tax. My lords, I've got paragraph B, my lords, at page 70, down below. The element of intent to evade tax, which is a sine qua non for invocation of section 130, stands established by following cumulative facts. Use of a non-genuine taxpayer for issuance of invoices, loading of goods from an undeclared and unknown premises, admission by the driver that documents were handed over by an unknown minor and he was unaware of the place of loading, non-appearance of consignee or consignor and conveyance owner despite summons, findings of the enforcement authority that MBS Traders was created to issue fake invoices for commission.
Now you can file an appeal against this order.
Your Lordship, my humble submission is like section 130 actually, section 68 read with 130 actually tells me to declare my tax value through the concept of e-waybill. The concept of e-waybill was actually came into the force only for the purpose of to curtail the evasion of tax payment. So evasion is something actually different from the present scenario. So they have not proven evasion will occurs only when I have not paid the tax. As per section 130. So there has to be evasion.
Now the same point you can raise in your
everything can be raised there.
You can raise in your appeal proceeding.
Your Lordship, if I have actually filed the appeal, then there will be two problems. Your Lordship. First problem is like my GST registration has been suspended. So I have already filed an appeal, and that I have a 270 days time period for revocation of my GST registration. So my GST registration was cancelled for the only reason that I'm not functioning from my principal place of business. So that will have a direct correlation with the present proceeding. So this officer, when I go for the present appeal, then the appellate authority will rely on the previous appeal which I have filed for my revocation. So which actually have the 270 days of time limit, but this one present appeal will have only a time period of 90 days.
I don't understand. I'm unable to understand what is.
So Lordship, they have actually cancelled my GST registration for which I was not functioning from my principal place of business, for which I have 270 days of time limit for filing my revocation with including the extended period of limitation. That is a separate proceeding where they have cancelled my GST registration. So if I file the appeal for saying that goods cannot be confiscated here, then this appellate authority will be relying on the decision of the previous appeal which I have filed for the reason that I was actually functioning from the principal place of business.
That cannot be a reason. Those are two different proceedings altogether.
My goods cannot be confiscated. My GST registration also cannot be cancelled for the same reason.
No, we will keep all those contentions open and clarify.
The order is dated 5/1/2026, my lords. They have filed a writ petition before this court on 17/1/2026. So if my lords permit them to file an appeal within 2 weeks from today, it will be to be considered on merits, without going into any other question of technicalities.
Your Lordship, till date, the order, communication, so cause notice, none of them was uploaded in the GST portal of the petitioner. Your Lordship.
Now, if we were to grant you an interim order of release on terms, and then you go and prosecute your proceedings before the appellate court. On same terms, what we are doing in other matters,
please, Lord.
We may consider, we'll subject to what they say, we can consider, and you go and file an appeal and raise all your contentions.
Please, Lordship, that can be permitted, but the only submission for your Lordship is like, till date, the appeal, the order and none of the thing was actually uploaded in the GST portal of the petitioner, Lordship. If such a thing was uploaded in the GST portal, then there will be a demand rises. So accordingly, we can make the payment and release the goods even under protest, your Lordship.
Let us see. Yes, M. Kumar.
My lords put them on terms, vehicle can be released and they can go and file an appeal.
On same terms, is it? Which is that?
Yesterday's matter, 25%.
25% of?
The penalty demanded.
And then?
75%.
These are all cases, my lords, where we take if we take an indemnity bond, will not serve any purpose, my lords.
Lordship, and also there is a judgment by Punjab and Haryana.
No, that, correct, that we'll see. We are considering other matters also.
So my only humble submission in this
25%
scenario is like
separate order.
section 130 and 68 actually tells the person to carry out the respective documents only, Lordship.
That
So
will-
officer cannot get into the prospective of whether I'm functioning from my principal place of business or not.
That
Then
will-
he can confiscate the goods for the same reason, because that is a separate adjudication that has to be independently, not relating to the section 130, Your Lordship.
Let us see that the matter at the time of hearing we can consider, not at this stage.
2020.
That's pass over. We'll take it up. You just have a look. Same interim order will pass. We'll permit you to go, and then you can fight it out in appeal. Pass over.
12, serial number 12, Anish Acharya.
Appealing for the petitioner, my lord. This is a 144 order, my lord, with regard to assessment. Ex-parte order.
See the PCI. My lords, Tirumalesh, my lords.
Counsel, Sri Tirumalesh is directed to accept notice. Mangalore. For both he'll appear, is it?
My lord, the order is of Mangalore, my lords. Assessment order is of Mangalore. So with respect to Mangalore, my lords, he'll take notice, my lords. But the respondent number 1 and 2, my lords, have no say in this. The assessing officer will take a call, my lords.
So he has to impede somebody.
We has to implead, my lords, the assessing officer.
Ah.
Annexure A, the person who has passed annexure A.
So then you impede there.
Let him implead the assessing officer, my lords, on the Bangalore
Krishna
PCI.
makes a oral request to implead
The jurisdictional assessing officer, my lords.
jurisdictional assessing officer as an additional respondent. In light of the oral request made, which is acceded to, the jurisdictional assessing officer is permitted to be arrayed as an additional respondent. Necessary amendment to be carried out to the cause title. Learned Counsel Tirumalesh is directed to accept notice for the jurisdictional assessing officer. Learned Counsel Sushant Tiwari accepts notice for 1
No,
and
no, my lords.
Who
Maybe-
appears for 1 and 2?
My lords, the Union of India, my lords, is Shantha Bhushan. Formal parties, my lords.
Two.
I'll take notice, my lords, for Union of India.
Madan Pillai for 1. Sushant Tiwari for 2.
Only 1 year. Only for 1, my lords. Only for 1.
You'll accept.
Yes, my lords.
Sushant Tiwari for 1.
Yes.
2.
2, my lords, Tirumalesh, my lords.
Tirumalesh for 2 and the newly added respondent. He lists the matter in the same stage on 11th.
13, Vishwanath K.
Worship, this is a case where ex parte order in original has been passed based on income tax return 26 CH data, Worship. And my client is a woman entrepreneur undertaking manpower services for various business entities, and wherein the tax is payable under reverse charge, Worship, in terms of this notification.
You want to verify?
My lord, I have verified it, my lord. Para 8, we have provided abundant opportunities, my lord. The petitioner has not replied or neither appeared. Hence, the adjudicating authority was forced to pass ex parte order, my lord. Para 8, personal hearing.
Lordship, the reason for non-appearance is because of purely medical condition, Lordship. When she is a woman entrepreneur undergoing precious pregnancy, Lordship, from 2020 to 2022, she was undergoing precious pregnancy, annexure E, Lordship, medical records. When she could not attend these hearings.
Annexure?
Annexure E, Lordship.
Page?
66, Lordship. Okay. Last, 4th line, Lordship. Maybe because of that, she is going critical medical condition, Lordship. in terms of precious pregnancy, and she could not appoint a proper consultant to take this matter. And especially, Lordship, when the matter is under reverse charge, Lordship, and covered by Lordship's own decision in
Item number?
Lordship.
Which item?
Annexure 66, Lordship. Okay, item number 8, Lordship. Serial number 8.
Huh?
Serial number 8. Serial number 8 in respect of security services.
Supply of manpower.
Yes, Lordship. And they have taken registration as manpower services only, Lordship. And they were in the bona fide belief that service tax is payable under reverse charge, and therefore they could not do proper submissions, Lordship. And they have almost 100 employees, Lordship, as of today. And annexure F and G, Lordship, provides for PF data, Lordship. A sample only we have given.
Yes.
In light of that, Chinmaya Seva Trust.
Relegate back to the first level.
Chinmaya Seva Trust. The petitioner has called in question the correctness of the order. Where is the order?
Order annexure B, Lordship.
Annexure B, my lord, 57.
37, Lordship.
37.
Order in original. Whereby,
Lordship may kindly refer to para 3.
yes, whereby after adjudication, demand of service tax has been raised. Full stop. Petitioner submits that the order of adjudication is based on inputs received from the Central Board of Direct Taxes. Full stop. It is submitted that the authority, while raising the demand for service tax, has relied on the declaration made in the income tax returns. And while noticing that the service tax returns is not filed, has adjudicated the matter. The counsel for the petitioner submits that petitioner, due to bona fide reasons, did not respond to the show cause notice and relies on the medical records at annexure E. Full stop. It is further contended that the services rendered by the petitioner are supply of manpower, and as regards such services, the tax is to be paid under reverse charge mechanism by the person who avails services. Full stop. Reliance is placed on Schedule 2, is it? What is this?
Table of notification, Lordship.
Has relied on the notification dated 20th June 2012. Vide notification number 30/2012 service tax. Full stop. While drawing attention to the table at item number 8, is pointed out that the obligation to pay service tax is only on the person who receives such manpower supply, and there would be no liability on the service provider. Full stop. Reliance is also placed on the directions passed in WP 1154 of 2023. Full stop. The perusal of the order of adjudication would indicate that the authority, in the absence of any reply and noticing that the petitioner had not filed service tax return, has proceeded to adjudicate the matter. Full stop. Peruse the order dated 37/25, passed in WP 1154 of 2023. Repeat para 10. 11, and 11. Next, in light of the above and in light of the contention raised by the petitioner as noticed above, the order in original at annexure B is set aside. Matters remitted to the stage of reply to show cause notice. Authorities to take note of the observations made in the order dated 3/7/2024 passed in WP 1154 of 2023 and connected petitions as extracted sutra, in specific the observations at para 10 of the order as may be applicable. All contentions are kept open. You have made needless to state, petitioner is at liberty to make out a reply to the show cause notice. All contentions are kept open. Petitioner to appear before the respondent number.
Respondent number 1.
Respondent 1, Your Worship. Petitioner.
1 on without waiting for any fresh notice. Accordingly, petition is disposed of.
Please.
14, Srihari, Akash P. Shetty.
For the petitioner in this matter, madam. This is a matter where the input tax credit has been blocked under 86A. It is squarely covered by the K9 enterprises versus state of Karnataka. Lord, I've annexed the single bench judgment. I'm producing the original bench that supersedes the single bench.
Yeah. What are the facts?
No, they have not. The respondents have blocked the ITC input tax credit of the petition without
page?
Page 8, my lord. Facts of the case.
No, where is the order?
There is no order, my lord. I've annexed the screenshot of the ledger annexure B.
Annexure?
Page number 29 and 30.
Blocked.
They blocked it. And to the extent of negative balance, my lord, that is covered by annexure.
Correct. The reason for blocking?
They have not given any reason, my lord. There is no formal order given. They have just blocked it, alleging that we have availed.
Yes.
No notice that was issued, my lords. There's no notice that is issued.
So 86A pre-decisional notice.
Blocking date.
21/11.
1 year is already over, no?
They have not received any notice or any.
21/11. Prayer column, they say the order is dated 21/11/2024. This blocking will be valid only for a period of 1 year under 86A.
So automatically it stands revoked.
It goes. It has to go.
Then you verify.
It's been more than a year now.
So when you find out now, they're saying it's only for valid for 1 year.
No, my lord, the screenshot was taken at the time of filing of petition. It is still remains blocked, my lord. In the portal, the ITC still remains blocked to the extent of negative balance.
Let's whatever it is, Manoj, if it is a blocking under 86A, if my lord turns to rule 86A, Manoj. Manoj should get the third proviso, sorry. GST.
Rule is it?
Rule 86A, Manoj. The third, sorry, 86A within brackets 3 members.
Yes.
That such restrictions shall cease to have effect after the expiry of a period of 1 year from the date of imposing such restriction. So whether it is
otherwise, sir, we can simply make a declaration without entering into merits. In light
yes,
of
since 1 year has expired, it automatically goes. If it is not taken out, the respondent has to take it out
forthwith. the
That's, I think I'll take notice for respondent number 4 and 5. Copies.
M. Kumar accepts notice for respondent 4 and 4.
4 and 5.
4 and 4.
I don't have the file.
4 and 4. It says 4. Petitioner seeks for correction of the array of parties on oral request. The petitioner is permitted to correct the respondent number, array of respondent numbers. And Government Advocate M. Kumar accepts notice for respondent
4 and 5.
4 and 5. Counsel Akash Shetty accepts notice for respondents 1 to 3. The petitioner has called in question validity of action of respondent number 1 in blocking the petitioner's electronic credit ledger by invoking power under section 86, rule 86A of the CGST rules 2017. Reliance is placed on the screenshot of the electronic credit ledger at
The
annexure B.
printout, man. It's a printout of the electronic credit ledger.
The printout.
In the GST portal.
Printout of the electronic credit ledger at annexure B, which petitioner submits, would indicate the blocking of the credit ledger. Full stop. The petitioner has raised various contentions, including prior to exercise of power under 86A, Rule 86A, there ought to have been pre-decisional hearing. Full stop.
Lord,
Next.
I've also taken up a contention in para 10 that after the expiry of 1 year, it shall cease to exist, but it is still there.
It is further, without further, it's further submitted that despite the lapse of 1 year and 2 months as on the date of filing the petition, despite the automatic cessation of an order blocking the electronic credit ledger, the same loses force by virtue of stipulation under Rule 86A3.
And para 19, my lord.
Same order continues as on date.
The respondents are not permitted to block the ledger to the extent of negative balance. It is covered by ROM and metal, annexure D, my lord.
It is also submitted that the petitioner, the respondent authorities are not permitted to block the electronic credit ledger where there is a nil credit or negative balance.
To the extent of negative balance. They're not allowed to block it to the extent of negative balance.
Correct. Where there is a nil credit or a negative balance.
Yes, much more.
Next. However, it is noticed that the blocking of the electronic credit ledger is purportedly effected on 21/12/2024. Full stop. Rule 86A3 reads as follows. Next, in light of the above, the restriction imposed by blocking the electronic credit ledger ought to cease to have effect after the expiry of period of 1 year from the date of imposing such restriction. Next, taking note of the assertion of the petitioner that the act of blocking the credit ledger is subsisting till date. In light of the mandate under Rule 86A subclass 3, it is declared that the blocking of the electronic credit ledger ought to have stopped operation as on 1 year from 21/11/2024, and accordingly it is declared that the action of continuance of blocking of electronic credit ledger is illegal, and the blocking is deemed to have ceased to be in operation after a period of 12 months. Accordingly, the respondent authorities to unblock the credit ledger forthwith. Accordingly, petition is disposed of. All contentions is disposed of.
Much obliged.
15, Manohar, 0 Niralagi.
Because ಬೇರೆ ಕೇಸ್ K9 ಒಂದು correct ಮಾಡಕ್ಕೆ ಹೇಳಿ. You please correct your petition.
4 and 5. 15, Manohar.
Yes.
Petitioner is a proprietary concern to engage in business of trade, register books, notes books, order books, receipts books and all. The GST audit under section 65(6) conducted by the audit team covering the period July 17 to 20 for the assessment area 17, 18, 20. During the course of audit, it's observed some of the petitioner have short declared the taxable value, sales invoice and all. So thereafter, show cause notice was issued and our auditor has appeared, kindly see on page impugned annexure F, page 100, point number 11.1. I have carefully gone through the records of the case. Show cause notice issued to the Assistant Commissioner, issued by the Assistant Commissioner Bangalore and documents available in the file. Since the assessment failed to file the written reply, proceed to decide ex-parte minutes. So that's my concern. I have failed to produce the books of account. My auditor was appeared before the personal hearing before the authority and requested in previous page number 99. He appeared and point number 10, personal hearing was appeared and requested by following the principles of natural justice, the taxpayer would provide with the opportunity of personal hearing. Wide letter so-and-so, Shri so-and-so authorized representative had appeared for personal hearing on so-and-so. It is during the physical hearing and had sought 10 days time to submit the details reply to show cause notice and produce. But he has not produced, and based on the failure on the production of books of accounts, the passed an order without giving an opportunity. I have all the books of accounts is it's with me. The auditor has is unable to. That is. No, I'm not blaming the department. It is my mistake and my auditor's mistake. So that's the. I'm requesting only under 226 because
the auditors will have to file now writs to protect their personality rights.
Yes. So kindly allow the petition and within 15 days I'll produce the necessary books of accounts and where opportunity.
Petitioner has called in question correctness of the order at annexure F, which is the order in original passed under section 74. Petitioner submits that petitioner has participated in the proceedings and made out reply. However, while availing the opportunity of a personal hearing on 20th September 2024, the authorized representative had sought for 10 days time to submit a detailed reply to the show cause notice. You have not replied, is it?
I have not replied. I sought just.
Yes. ಅಲ್ಲಿ ಮೇಲೆ ಏನು ಬರ್ತಿದ್ದೀವಿ ಮೇಲೆ ಅಲ್ಲ but did not make out reply. ಆಮೇಲೆ as well as Full stop, show cause notice, full stop. Petitioner submits that without accommodating such request, the respondent authority has concluded the proceedings. It's further submitted that petitioner has material including books of accounts to demonstrate and meet the grounds as made out in the show cause notice. Next, taking note of the assertion of the petitioner and having perused the order, it is noticed that the authority has proceeded to complete the adjudication in light of petitioner not having availed of the opportunity granted during hearing. Nevertheless, it's to be noticed that petitioner had the authorized representative of the petitioner had made a request of adjournment of 10 days, which appears not not to have been accommodated. Next, noticing that the authority has proceeded with the matter in light of the petitioner not having made out his reply and also taking note of the financial consequences that visit the petitioner if the order is upheld. As an additional opportunity, it would be appropriate to set aside the order at annexure F and remit the matter back to the stage of personal hearing stage. Needless to state that the petitioner is required to be vigilant and cooperate with the proceedings and not seek unnecessary adjournments. The petitioner to be present before respondent number
2.
Respondent number
2.
2 without further notice on. Petitioner to cooperate in expeditious disposal of the proceedings. All contentions are kept open. Accordingly, annexure F is set aside.
16, Ajay, J.
Yes.
PDA Manshankari layout scheme members. There was a site allotted to one set of persons from whom I have purchased. Now, my lords, what has happened is that acquisition has been set aside insofar as where my site is located. In fact, my lords, identical matter had appeared before my lords a month back. There, my lords, there was actually a consideration. There was an order passed to allot a particular site, and then, my lords, ultimately in the writ appeal, my lords, they said that the acquisition, that order was set aside. Then again, they filed a fresh petition. I'd asked. This is a case of they had not made a representation at that point in time. So it's a case only of consider representation.
Who appears for the BDA there?
Mr. Charati, my lord had ordered notice to Mr. Murgesh Charati.
Shri Murgesh Charati is directed to accept notice for the respondent. List the matter in the preliminary hearing list on.
My lords, can I make one request, my lords? My lords, is it possible, my lords, to consider asking BDA to reserve one site in the same layout if it is available for allotment to the.
No, so we'll pass an order. Order on the next day. Yes, we'll start next. Counsel for the petitioner submits that the respondent BDA may reserve a site in the same layout.
Same layout.
Huh?
Yes.
In the same layout. In the peculiar facts of the present case. Full stop. The counsel for respondent BDA to look into such request and respond on the next day. List the matter in the preliminary hearing list on. What is this IA 1 of 26?
My lord, it's for dispensation, my lords, regarding dispensation of
the
my lords, original of annexure R, my lords. Annexure R, my lords, is my representation.
IA 1 of 26 and 2 of 26 are allowed, subject to the undertaking that if required,
My lords, original is with the BDA. This is only an acknowledgement which I obtained.
IA1 of 26 is allowed. Petitioner dispense with production of certified copy of annexure R as it's submitted that original has been submitted to the BDA. Next, IA2 of 26 is allowed. Petitioners dispense with the production of typed copies for the present subject to the undertaking that if called upon, the time of hearing typed copies will be produced. Next.
Obliged.
17. Samit
My
Gupta,
lord, I
17.
appear for the petitioner in this case, my lords.
Yes.
This matter pertains to section 130, my lord. The goods in transit were detained and confiscated, my lords.
Yes.
Okay, let's on two grounds. Firstly, is that the confiscation proceeding itself is time barred because the confiscation is consequent to inspection proceedings, my lords.
Is there any delay?
No, my lords.
Delay in physical inspection, any delay is there?
Yes, my lords. It's a delay of 1 month, my lords. The inspection has to be conducted within 3 days from the date of from passing physical verification order.
Could it? I passed an order
Please,
on same terms. Huh? Same. Huh.
It's 25% cash and remaining indemnity bond.
Huh.
Please, minutes. I bore on to that. Minutes.
Orders passed under 130.
Yes, minutes.
Huh.
Please.
No, but this something else you have to do him. This 129.30 right now, okay, something is, but if you find that the law is ineffective, then something else must be figured out. The petitioner has sought for setting aside of the notification at annexure A, comma, has also sought for setting aside of the order at annexure B. Annexure B is what order? 129 or
No,
130?
Annexure B is the order passed by the Commissioner of Commercial Tax conferring the functions of proper officer.
Comma. Petitioner has also sought for setting aside of the order at annexure C, which is an order passed under 130.
130 minutes.
130 of the GST Act. The petitioner, counsel for petitioner submits that there has been delay in conducting physical inspection of goods. Full stop. Submitted that this court in identical circumstances where there has been such delay had passed an interim order on 12/2/2026 in WP 1563 of 2026, and an identical interim order may be passed in the present matter also. Repeat.
This is the interim order you are relying on?
From interim order passed, repeat matter. Till page 5. Next. The impugned order of detention orders at annexure.
Annexure T ballots.
Huh?
Annexure T.
That order copy that I gave, Malaj, they are relying on a different order copy, Malaj. They want that order, not this order. I'm sorry, Malaj. Could you give it? They want an order with regard to depositing 25% of the amount determined in the order. I think yesterday I got confused between two orders.
In an identical circumstance, in WP 5195 of 2026, I had passed an interim order, and on same terms An interim order may be passed in the present matter also. Peruse the interim order passed in WP 5195 of 2026 on 20th February 2026. Interim order reads as follows. Accordingly, in the present matter as well, taking note of the interim order passed as extracted above, there would be an interim order directing release of goods and conveyance of the petitioner, subject to the petitioner making payment of 25% of the amount as determined in the order of confiscation at Annexure C.
C, my lords.
And an indemnity bond to be furnished as regards the remaining value as determined in the order of confiscation, with the further affidavit of the petitioner that they would adhere to the final orders to be passed by this court. Full stop. The affidavit to be filed within affidavit and indemnity bond.
The moment they do it, Malaj will release the vehicle.
Affidavit and indemnity bond to be filed forthwith before the authorities. Upon the payment of 25% as referred to above and furnishing of indemnity bond and affidavit, the goods and conveyance to be released forthwith. Next, it's made clear that the affidavit should also contain an undertaking that they would not withdraw the petition and abide by the final orders passed by this court, and in the event of any violation of the undertaking in the affidavit, petitioners would be exposing themselves for proceedings in contempt of court.
Please. Please, Milord.
Relist after 2 weeks.
18, Syed.
Please, Milord.
Serial number 18, Syed Kamru.
ಇದು ಒಂದು ಇಟ್ಕೊಂಡಿರೋದು ಇದು ಅಭ್ಯರ್ಥಿ.
Sir, challenge in ex-parte order that was passed due to a difference that was found in the ITC claimed in GSTR 3B and the ITC reflected in GSTR 2A, my lords. Now, this difference had arisen due to the fact that certain suppliers had uploaded their invoices belatedly, my lord, due to which the corresponding invoices details could not be reflected in the GSTR 2A, my lord. The proceedings were entirely ex-parte and we could not take part in the proceedings, my lords.
Yes.
If
Yes, Kumar.
opportunity is granted to the petitioner, my lords, we can showcase that the ITC claim was based on genuine transactions, my lord. We have the invoices for the same as well.
Annexure is the impugned order. I can't address any arguments.
The petitioner has sought for issuance of writ in the nature of certiorari to set aside the order of adjudication under section 73(9) as well as the summary order. Petitioner submits that the order of adjudication is passed on the premise that the petitioner had availed excess ITC in respect of, within inverted comma, all other ITC, close inverted comma, in table 4 capital A within bracket 5 as compared to available ITC in GSTR 2A. Full stop. The counsel for the petitioner submits that the suppliers have belatedly uploaded their belatedly uploaded the supply details.
Their invoices, yes.
Their invoices. As a result of which there is some apparent discrepancy, full stop. However, it is submitted that due to bona fide causes, the petitioner was not in a position to make out reply to the show cause notice, but if provided with an opportunity, the petitioner would demonstrate that there is no discrepancy as regards to ITC claimed when compared to declarations made by their suppliers. Taking note that the order of adjudication has proceeded without any reply of the petitioner to the show cause notice on merits. It would be appropriate, considering the consequences that would visit the petitioner if the impugned order is upheld, to set aside the order at annexure A and remit the matter back for fresh consideration to the stage of reply to the show cause notice. Accordingly, the order at annexure A and the summary order at annexure A1 are set aside. Matter is remitted to the stage of reply to show cause notice. All contentions are kept open. Petitioner to appear before the respondent without further notice on
23rd of March. 23rd March.
My lords, there's an attachment order at annexure G as well, my lords, that was.
Consequent to setting aside of the order of adjudication, the authorities are directed to resign their instruction to the banker for attachment of the bank account forthwith upon receipt of certified copy of the order. All contentions are kept open. Name Kumar accepts notice for the respondent. Accordingly,
Not impose a condition of 10%.
huh?
My lords, there is
The
small
petitioner.
Amount is very small,
Huh.
so it can be waived.
Taking note that the demand of tax is a small amount, the normal insistence of the court to impose a condition of 10% of demand of tax to be satisfied is waived.
Much obliged.
19. Gurishankar Prasad.
Yes, it appears, scanning the mistake. It appears there was some mistake in the scanning.
Yes, my lord. Actually, it is, there was some mistake in this. Actually, it is services rendered to education institutions by the security agency, which is an exempt service as per the notification 12.
Today, this matter was listed yesterday.
Correct, correct.
My lords directed them to furnish details of what payments have been, what amounts have been recovered, my lords, in pursuance to the order in original.
Yes.
My lord, actually, we have got one statement, which is finally pending statement for this realization, which is coming to around 39,000 after paying payment of 38 lakhs.
38
lakhs. 39,000 is the balance which is to be paid on this issue.
39,000 you have paid.
No, 38 lakhs has been paid, which is recorded on page number 11. This is the pending amount to be payable, that's it. Page number 11. Para 7.
Yes, that amount you have paid.
Yes, paid.
What are the facts now? What are the facts?
My lord, basically the facts are the petitioner is in the business of security agency, wherein he has rendered services to education institutions, which is exempt from payment of GST as per notification 12/2017. And the serial number of that is 66, heading 99992. But actually, during the course of the
serial number,
serial 66,
yes,
heading 9992.
Security
services provided to an education institution by way of Roman 3 security or clearing housekeeping services performed in such education institutions.
Now this is exempt.
Exempt.
Now what does the authority say?
Actually, my lord, this is actually there was a participation by the petitioner, but for the fact that the documents were not produced during that point, that has been confirmed as a tax. And actually, in this petition, the relevant invoices have been enclosed, my lord. If you see page number 40 onwards, 20, we have enclosed sample invoices, my lord. 20, 21, 22, these are the sample invoices, which clearly states that these are the services rendered to education institutions. Icon International School, Orange School, then Premier High School, all these things.
The petitioner has called in question validity of the order of adjudication. At annexure B and the summary order at annexure C, which is the order of adjudication at annexure
Annexure B, my lord.
B.
B.
And then
739.
what is C and D?
C and D summary order.
And the summary orders at annexure C and D. Full stop. It is the submission of learned counsel for the petitioner that though the petitioner had participated in the proceedings, however, due to incomplete presentation of the petitioner's case before the authority has concluded the proceedings, raising the demand. It is submitted that if the petitioner is given an opportunity to appear before the authority, the petitioner would make out their case that the services which have been adjudicated as being taxable are in fact exempt. Full stop. Reliance is placed on the notification 12/2017 dated 28 June 2017 and in specific to entry 66 within inverted comma heading 992 close inverted comma. It is further submitted that the authority has recovered taxes amounting to 38 lakhs 5,355 and the
Actually, it's more than that, my lord, but it has been recorded as 38. Actually,
and there has been further recovery as well. Counsel Shri N. Kumar submits that the amount of recovery is a matter of record and to be verified. Next, taking note of the assertion of the petitioner regarding the exemption claimed by relying on notification 12 of 2017 and noticing that the authority has passed an order which according to the petitioner would not have been passed if the petitioner had placed materials such as invoices at the appropriate point of time. It would be appropriate to set aside the order at annexure
BCD, my lord.
BCD and remit the matter back for fresh consideration before respondent number
2.
There's
also one more submission, my lord. There is a mismatch of GST 1 and 3B also. That can also be considered.
Once it goes back, everything is kept open. Lords may kindly make an observation that this order is being passed for the reason that substantial tax amounts have already been.
Yes.
One sentence. Petitioner further submits that there is a mismatch between GSTR
1 and 3B.
1 and GSTR 3B, and reconciliation would be made if opportunity is provided. Said assertion is placed on record. Last. Taking note the order is also being passed. Taking note that there has been substantial recovery of tax, and in order to enable the petitioner to take a stand as noticed from the assertion referred to above. Accordingly, petition is disposed of. Petitioner to appear before respondent number 2 without fresh notice on. Needless to state, if the petitioner were to be absent or not take benefit of the participation in the present proceedings, indulgence granted by the court would stand revoked. Needless to state, the amount of tax recovered would be subject to adjudication, which is directed to be redone. All contentions are kept open.
Much obliged.
20, Vineta Secretary, 20.
One sentence, sir. The explanation.
Yeah, to serial number 20.
Just one. Taking note of the explanation made by the registry. The explanation is accepted. Necessary reminder to be issued to the scanning department to ensure that there are no lapses henceforth as has been noticed herein.
20.
Now, serial number 20 and 20.1, same assessee, different assessment here, 2018, 19 and 1920. The writ petition is against the rejection order of application 119 2B, Your Lordship. The assessee is a cooperative society eligible for the deduction of 80P2B, Your Lordship. 80P2. But they have filed the return belatedly, and they have filed the return belatedly with a genuine reason, Your Lordship. The secretary who was managing the daily activities, Your Lordship, has fallen sick and he is suffering from serious disease, Your Lordship. For that, medical report also has been submitted before the authority. Annexure A, page number 22, Your Lordship, is the order for the rejection of 119 2B application, whereas paragraph number 3, Your Lordship, filed the application with genuine reason, paragraph number 3. In the petition, the assessee submitted that day-to-day affairs of the cooperative society was being managed by Secretary Sri Krishna Murthy, and due to his ill health, he couldn't attend to his duties regularly. It was also stated that the society was under the belief that its income was fully exempt under Section 80P of the Income Tax Act, and it was not aware of the new inserted clause 2 of Section 80 AC. It was further stated that the auditor who audited the account also did not advise it to file the return of income on or before the due date. It is also stated that the assessee society filed its return for the relevant assessment year on 29/12/2018. In view of this fact, the assessee society has requested to condone the delay in filing the ITR for assessment year 18-19. Whereas in para 6, Your Lordship, the ratio of the order, Your Lordship, I have carefully considered the facts of the case, the report from the field authorities and the submission made by the assessee society. The assessee has stated that the delay in filing the return for assessment year 18-19 was due to the ill health issues of the secretary, Sri Krishna Murthy, and has also submitted the medical report pertaining to the secretary. The medical report submitted by the assessee society is dated in 12/2019, which is after the due date for filing the return of income for assessment year 18-19, that is 31/10/2018. Also, in the absence of secretary, the other officer bearer who has signed the financial statement could have facilitated the filing of the return of income. Therefore, the claim of the assessee is not found to be acceptable. Further, the assessee society has stated that it was unaware of the provision of Income Tax Act 1961. Being unaware of the statutory provision and consequently not filing the return of income doesn't exhibit the due diligence on the part of the assessee in complying with statutory obligation, and hence do not point to circumstances which are beyond the control of the assessee. Thus, it is clearly seen that the reason submitted by the assessee.
Certificate they're saying is 2 months after the last date.
Yes, Your Lordship, but he was suffering from the paralysis and the heart attack, Your Lordship. When he was admitted to the hospital, the summary copy of the hospital, Your Lordship, it was submitted. But he was suffering during the period of this assessment year, Your Lordship. It is page number 30, page number 29, Your Lordship. They have filed a leave letter also, whereas the translation is on page 30. Page number 29, and the translation is on page 30.
Yes. Yes, Dilip.
On this, Your Lordship, I'm relying on this two judgment.
What for? The petitioner, some cost you pay. The
It's a
petitioner.
cooperative society, Your Lordship. I'm relying on this judgment, Your Lordship, for the same assessment, Your Lordship has already passed the judgment, Your Lordship.
The petitioner has called in question the correctness. Called in question the correctness of the.
Return has to be filed within due date for any reduction under 80 feet. Based on this circular, Commissioner has rejected para 2. So far as section 80 of the Act is concerned, Finance Act 2018, 80 AC of the Act with effect from 1/4/2018 provide that deduction shall not be allowed unless purpose. Wherein computing the total income of an assessee for any previous year, 11 to 16th year, on or after Roman 2 is known. The first day of April 2018, any deduction is admissible under any provision of this chapter under the Act. The deduction in respect of certain, this is relevant.
Which one?
Para 2, Roman 2, para 2 Roman 2.
Last first day of April.
Please, first day of April, any deduction is admissible unless any provision of this chapter under the 18 deduction in respect of certain this 18 feet falls under this chapter. If they want deduction, returns has to be filed within the due date.
But technically, they don't have the power to condone. Technically,
The section itself, section 80 is AC. Section 80 AC.
so now what do we do?
Lordship, in this judgment also, it has been clearly mentioned, Your Lordship, even it is not permitted for the respondent to condone it, but Lordship has directed to condone even beyond 5 years, Your Lordship. The first judgment, Jitendra Mohandas.
Which one?
Jitendra Mohandas. For the same assessment here, Your Lordship, where 119(2)(b) was rejected and it is beyond 5 years, Your Lordship.
This case, filing return on the minutes, there was a mistake with that.
And even Your Lordship, Vidyarani, one more judgment I have placed, Your Lordship, and for this, Your Lordship, 670 days delay has been condoned.
What is the reason?
It's a genuine hardship of the reason for the account.
What is the reasoning assigned by the court?
For the failure of the accountant, Your Lordship, who is participating in day-to-day activities.
I don't find any reasoning. The petitioner has sought for setting aside the order.
The Expedition Double Report 2/3 of 2026 plus the delay of 90 days.
87 days.
45/04 of 2020 plus the delay of 40 days.
Now today, here in this matter, how many days?
No, both are listed.
Now,
Two matters are. First matter is first matter 40 days. Second matter is 90 days.
They have filed the return
Dated
along with the application.
along with the application has been.
No. In WP 4504 of 2026. The petitioner society has challenged the order at annexure A passed under section 119 within bracket 2 within bracket B of the income tax 1961. Rejecting the application seeking condonation of delay in filing return of income for the assessment year 2019-20. Now in the other one, the same reason or some
Same reason, Your Lordship, but there is a small correction, Your Lordship. For the first matter, Your Lordship, for 4423, there is a delay of 87 days, whereas the next matter, Your Lordship, 4504, there is a delay of 141 days, Your Lordship. They have calculated wrong. It is not 40 days. Same reason.
in WP 4423 of 2026, petitioner is called in question the correctness of the order at Annexure A passed under 119 2B of the Income Tax Act, whereby the authority has rejected the application filed seeking condonation of delay in filing the return of income. As both the petitions relate to the same SSC and the reasons made out in the application are identical, both the petitions are taken up together. Next, it is a case of the petitioner that the petitioner society is eligible to claim exemption of its income under section 80P of the Income Tax Act, and that the return of income was filed beyond the time stipulated in light of the secretary of the society not keeping well and suffering from medical ailments. He submitted that the medical ailments of the secretary of the society being a genuine cause, the authority ought to have condoned the delay under section 119 2B and permitted the consideration of the returns filed. Full stop. Next.
And small interruption, Your Lordship. Praying for personal opportunity, Your Lordship, personal appearance, Your Lordship, which I have prayed even in the application also. Date may be given and opportunity for personal appearance.
No, what appearance? You are condoning the delay.
Before
The peruse the orders in both the writ petitions at Annexure A. The reasoning and discussion are identical in both the orders. The authority has rejected the application while observing that even in the absence of the secretary, the other office bearers could have taken steps for filing of the return within time. Next, Learned Counsel for the Revenue would submit that the difficulty in considering the prayer as sought for is that there is a statutory mandate which requires the SSC to file the return within the time stipulated as noticed in the circular number 13/2023 within bracket F number 173/2023-ITA-1 close bracket dated 26/7/2023. It is submitted that the authority itself may not have had any power to condone the delay if return is not filed by the 1st of April 2018. Heard both sides. At the outset, it must be noticed that the plea of the petitioner that the secretary of the society was not keeping well is also supported by, have you produced any records? Medical record have you put?
Lordship, the medical reports are produced, Your Lordship.
Where? Page?
Page number 28, Your Lordship.
Yes.
And the leave letter also.
Yes, yes. In the,
And board resolution too.
the medical records produced as well as the leave letter addressed to the officer of the cooperative department. No doubt, as pointed out by learned counsel for the revenue, that the deduction could be claimed only if the return is filed within the time fixed. That is, in the present case, by 1st of April 2018.
The due date was 31st October 2019. The second case was 30th September 2018. Due date.
In the first case,
31st October 2019.
2019.
The second case was 30th September 2018.
ಏನು ಬರ್ತಿದ್ದೀರಾ? Fixed, fixed in terms of the circular referred to above. Full stop. Submitted that the return in WP number first case ought to have been filed 4504 of 2026, ought to have been filed by 31/10/2019, and in the case of WP number so and so ought to have been filed by 30th September 2018. Next. However, this court, in exercise of writ jurisdiction, may, in certain circumstances, making out a case of undue hardship and genuine cause, pass orders condoning delay. Taking note of the medical ailment as made out of the secretary, it would be appropriate to exercise such a plenary power in the peculiar facts of the case while noticing the medical record. Accordingly, the order at annexure A in both the writ petition is set aside. The return is directed to be taken on record and processed as per procedure. Yes. Accordingly, petitions are disposed of.
Much obliged.
21, Naveen GS.
Lords, I appear for the petitioner, my lords. In the last date of hearing, my lords, I was to clarify, my lords, whether an intimation has been sent as against the rectification application filed by us. At annexure D, page number 57. My lords, we have pleaded in para 9 that even though we have filed for rectification, no intimation or order has been passed.
No, what are the facts?
Lords, facts, my lords. 73(9) order has been passed even without considering our KVAT forms and KVAT returns, my lords. Order is at page number 37, my lords.
Yes.
Reasoning is at page number 55, my lords.
55,
my lords, 55.
Yes.
My lords, wherein they say that, my lords, we have not stated anything to show that 1,51,04,877 rupees in the VAT, my lords. 14th line, my lords.
Yes.
Thereafter, my lords, we file a rectification application at page number 57, annexure D. under section 161, my lords.
Page
57, my lords, 57.
For the rectification of
The
the
original order, my lords, order in virginal. Seeking to look into the documents, my lords, the TDS certificates produced at page number 60, my lords, 60 to 63, and VAT form 240, my lords, at page number 64. At page 66, my lords, wherein my turnover has been showed as 1 crore 58 lakhs 4,876 at page 66, my lords. The first column, my lords, page 66.
Yes.
But my rectification application was not considered and no order or intimation has been passed by the second respondent. Subsequently, my lords, I file an appeal before the first respondent at page number 68, my lords. That is the appeal before the first respondent.
Yes.
Which was rejected, my lords, at page number 76 only on the ground of delay. In the last date, my lords, the revenue was sought, my lords. What is the date of intimation with regard to rejection of my rectification application so that the matter can be remanded back before the appellate authority to consider on merits? But no intimation or order has been passed against my rectification application, my lords.
Well, subsequent to this order passed by the first appellate authority, my lords, at page 78, my lords, they file an application for restoration of the appeal. And my lords, in that, my lords, some averment has been made that they filed it against an endorsement.
Lords, that
I can
endorsement
record,
is
my lords, only by the order that is passed by the first appellate authority, which is at page
amnesty
81.
scheme, my lords. That is an amnesty scheme, my lords, SPL 07. That's an amnesty scheme which we wanted to avail, my lords, to waive off the interest and penalty. We have stated at page number 79 at the bottom, my lords. Copy of the rejection order SPL 07. SPL 07 is nothing but the amnesty scheme, my lords. Forum for an amnesty scheme. Even if that is the date, my lords, the revenue want to contend 4 months from 23/4/2024, my lords. We are very well within the limitation period.
Correct. The only point the revenue wants to verify if some orders.
My lords, kindly see, my lords, at page 81, my lords. The first appellate authority, my lords, issues an endorsement rejecting the application for restoration of the appeal. My lords, I'll just take, my lords, the second paragraph, my lords, now wide reference 1.
Yes.
My lords, there we say, you have filed an application for restoration of the rejected appeal, stating that the appeal was filed within the statutory period prescribed under section 107(1) of the CGST Act against the endorsement issued by the respondent. But this endorsement, I don't find it in the writ petition, my lords. Whether at all they have filed an appeal against the order in original, or they have filed it against the order in original, my lords, they filed an application for rectification, which is supposed to have been rejected by this endorsement.
No, lords, there is no rejection of that rectification application. The rejection we are mentioning here is only the application under amnesty scheme. SPL 7, my lords, kindly at page number 79. The copy
Then,
of the
my lords,
rejection.
the appeal itself is not maintainable because they should have filed the appeal against the order in original.
We have filed it, my lords. They have not considered it. They have rejected on the basis of delay, my lords. We have waited that the second respondent would intimate or communicate the order on rectification. There is no communication. Thereafter, we file an appeal before the first respondent as against the original order. My appeal has been dismissed only on the ground of delay.
You want to find out, is it?
Please, I'll do it now because I'll see what has happened to their application for
rectification.
Otherwise, also, my lords, I see that the order passed by the first appellate in the order in original seems to be an ex parte order. At page
No, my
56.
lords, we have given reply, my lords. It is not an ex parte order.
Then,
We have given
then I'll have to
detailed
take the
reply.
record.
Till such time, my lords, since it relates to KVAT period, my lords, we have given them the form number 240 as well as the TDS certificates, which were not considered by the assessor, my lords, while passing the order in virginal. Let there be a stay, my lords, of the annexure B. If not, my lords, let it be remanded back before the appellate authority for consideration on merits, my lords.
You want to verify?
Please, no, it cannot be done, my lords. Delay cannot be condoned and the matter cannot be remitted to the first appellate authority. Now, my lords, why I was saying is page 56, my lords may kindly see. The first paragraph. I mean, ಈ ಕಚೇರಿಯಿಂದ ಶೋಕಾಸ್ ನೋಟಿಸ್ 30 ದಿನಗಳಿಗಾಗಿ ಹಾಜರುಗಳು ಆದರೆ ಕರದಾತರು ಇದುವರೆಗೂ ಹಾಜರಾಗಿರುವುದಿಲ್ಲ ಮತ್ತು ಕೇವಲ ಅಂತರ್ಜಾಲದಲ್ಲಿ ದಾಖಲಿಸಿದ ವಿವರಗಳನ್ನು ಪರಿಗಣಿಸಿ ಕರ್ನಾಟಕ ಸರಕು ಮತ್ತು ಸೇವಾ ಕಾಯ್ದೆ ತೆರಿಗೆ ಪ್ರಕರಣ 73
we can set it aside and then remand it.
But my learned friend says it is not an ex parte order, so then
it may be set it aside and it can be considered afresh, my lords.
But that rectification won't come in the way.
My lords, if no orders have been passed on the, I'll verify and get back on Tuesday, my lords.
Release the matter in the same stage on Tuesday. So if there is no order on the rectification, then we could reopen it.
Otherwise, also, my lords, an endorsement would have been issued saying that there is no mistake apparent on the record. So there is no question of rectifying, passing a rectification order.
Then I would
They
be
should have
within
put an against that order before the first appellate authority. Then, my lords, there would not have been any delay.
Then that would merge with the order in virginal.
The grounds of is filed before the first appellate authority. My lords, may kindly see at page 70. Page 70, my lords, paragraph C. This is the grounds of appeal filed before the first appellate authority. Para C, my lords, I got it, my lords.
Correct.
The appellant has requested for rectification void order dated.
Just check it out.
Yes, ma'am. They
Then
say
I would
against the impugned endorsement.
Correct. Though they are claiming it's amnesty scheme, anyhow you satisfy us.
I'll check the records and get back.
That is also, if that
Let
is
us see,
also, then it will go with 4 minutes. Kindly,
Let us release the matter in the same stage on
3.
Yes.
22.
Great for us.
Lordship, petitioner is a public sector undertaking of the central government. In the last hearing, 3 points were argued upon, Lordship. The challenge is to the impugned order in original.
Why was it adjourned?
Lordship.
Why was it adjourned?
Lordship, it was adjourned. That page, there were the main reason is, Lordship, the grounds on which the show cause notice was issued and the ground on which the order came to be passed were different. In page 45, I had tabulated the grounds, Lordship. If I may also pass on the relevant extracts from the order itself, Lordship. On different grounds, what was given in the show cause notice and what was finally passed in the order, both are very different, Lordship. And I had also tabulated what is the prejudice cost for each of the grounds. If Lordship see the first point, Lordship, the turnover difference. It says that the reply is not acceptable since amount mentioned in form GSTR 3B and GSTR 1 is not matching with the workings provided to the taxpayer. In response to this, I filed submissions. Now, the conclusion, Lordship, is submission has been of the taxpayer has been verified and found that the taxpayer mentions turnover has been reported both twice in form GSTR 1, but the taxpayer is unable to provide any reasons why the amendment in form GSTR 1 is not done to rectify the same, as per section 37(3) of the Act. And thereafter, it also says the taxpayer has not provided any reconciliation how the same is rectified in annual returns and reconciliation statement given in form GSTR 9 and GSTR 9C. For two statements, Lordship. First, the time limit for rectification under section 37(3) as stated by the department in the order, that has long expired, Lordship. So it is not possible to undertake a rectification as on today. And to the averment that no details have been submitted, I have produced my submissions. I have also produced for each of these grounds what information I have given in response. So the only limited aspect, Lordship, is my submissions were not considered. And the grounds on which the show cause was issued and the order came to be passed are completely different. It is not just for this ground, Lordship. Each of the grounds of Lordship may see. I will take Lordship through each of, to each of these grounds and the relevant documents enclosed in support.
Yes,
I'll complete my pleadings. Interim order may be granted, reserving liberty to seek for modification.
The petitioner.
Public technique. We cannot go anywhere.
Huh?
Public sector undertaking, central government. So money will be safe either way.
The petitioner.
Page 85, Lordship.
For setting aside of the order passed under section 73 at annexure F. Various petitioners also sought for setting aside of the summary of the order. Petitioners raised various contentions, including that the grounds made out in the show cause notice are different from the grounds made out in the order and the findings recorded. They submitted that in light of the same must be construed that there were violations of principles of natural matter requires consideration. In the interregnum, there would be stay of
Annexure F and Annexure G.
F and Annexure G.
Page 86.
AGA requests for time to complete his pleadings. It is observed that the revenue, upon filing statement of objections, may seek for modification of the interim order if circumstances are so made out.
Deeply obliged.
23. Rochana S. Babu, 23.
My lord, this is a service tax matter where the order in origin is passed purely based on the income tax returns covered by Chinmaya, my lord. Matter may kindly be remanded.
Covered by.
The petitioner. These are all old matters, is it? Okay. No, but now are you exempt? Is it barred by limitation? What is the ground you have made?
We are exempt, my lord.
Exempt.
Exempt.
What is the
Notification 25, right?
Yes.
24?
25. 25 of?
24.
25 of 2012.
Huh? You have a copy?
We have annexed it. We annexed it. I will produce it, my lord. I'll produce the
No,
copy.
I just want to know on what ground is saying exempt? A reverse charge mechanism or exempt straight away?
Exempt, my lord.
Huh?
Exempt services.
Just take me to that
Yes.
page 32.
1 second. Where is it?
25 of 2012.
25 2012.
So what is the service here? Under which head?
1 second.
Services provided to government.
Government, my lord.
So what is the nature of services?
1 second. I am into. I am BWSSB contractor, my lord.
Huh.
Construction services, sewage, pipelines, communication cables, and other civil engineering works.
Yes. That is exempt.
Yes, my lord. That is my contention.
The petitioner has sought for setting aside
Page
the
33, my lord.
Page
33. I've extracted the portion of the notification. Service provided to the government, local authority or governmental authority by way of construction, erection, commissioning, installation.
Yes. The petitioner sought for setting aside of the order in original dated 18/10/22 at annexure A, as also the show cause notice at annexure B. It is the case of the petitioner that the respondent authority
Remand to respondent.
has passed an order in original
One of the two. It says deputy.
adjudicating and raising a demand for service tax in terms of the Finance Act 1994.
97. No.
Huh?
94. 94.
Next. It is the assertion of the petitioner that the services provided were exempt, and accordingly the authority ought not to have proceeded for adjudication. It submitted that petitioner, due to bona fide cause, was not able to place reliance on the exemption notification, and if now provided with an opportunity, petitioner would demonstrate the absence of liability to pay service tax due to exemption. It is further submitted that the proceedings have culminated, have been initiated on the basis of inputs received from the Income Tax Department. It is submitted that this court, in identical circumstances where demand for service tax was raised on the basis of inputs received from the Income Tax Department and declarations made in the income tax returns, has passed certain directions, and on parity, present matter also. Directions as passed in WP 1154 of 2023 may be passed and proceedings be reopened with an opportunity for petitioner to make out reply to the show cause notice. Repeat para 9, 10. No, there is no appeal.
No, madam.
appeal.
No.
Only order in original.
Yes, madam.
Till 10. Till end of para 10. ಹಿಂದಿನ ಮ್ಯಾಟರ್ ನೀವೇ ತಗೊಂಡಿದ್ದ ಅವ್ರು ಮಾಡಿದ್ದಾರೆ ಅವ್ರು ಅಲ್ಲಿ ಒಂದು ಮಾತು para 11 to be verified ಅಂತ ಹಾಕಿ ಅವರು till end of para 10. Next, accordingly, in light of the above, the order in original at annexure
A is the order, my lord. Order in original is annexure A.
at annexure A,
Show cause notice is B.
annexure A is set aside. Matters remitted to the stage of reply to the show cause notice. Authorities to take note of the observations made in the order dated 3/7/2024 passed in WP 1154 of 2023 and connected petitions as extracted supra. In specific, the observations at para 10 of the order as may be applicable. All contentions are kept open. Needless to state, petitioner is at liberty to make out fresh reply to the show cause notice. Next, the petitioner to appear before the respondent number 1.
Two has adjudicated, one has issued show cause notice. Deputy or assistant is what they say in the show cause notice. One of the two is fine. So in the show cause notice, they ask me to.
To respondent number 1. without waiting for further notice. Accordingly, petition is disposed of. All contentions are kept open.
Yes.
The date could be fixed.
Date, man.
24th March.
Date.
24th March. 24 and 25, Rajana Shetty.
This petitioner's land has been acquired by APMC. Now, after Supreme Court order, they have sent a reference to civil court without depositing the amount, Your Honor, as under Section 677 of the Right to Fair Compensation Act.
You take out. Yes.
State government.
AGA accepts notice for the respondent. This is the matter. In the
Can it be connected with the other matter, Your Honor? The similar matter you have already heard.
Along with the WP number
4824
4824
of 26, Your Honor.
of 2026.
26, Your Honor.
26, Sandeep Uilugo.
What may I recall? So that matter which came up last week, the issue was with respect to when I file an appeal to the GST tribunal against an SMR order which arose out of confiscation. I had given a bank guarantee pursuant to a High Court direction to secure release of the goods and conveyance. Now the bank guarantee was valid and the goods have also been released. My appeal before the appellate authority came to be allowed. A few days later, the matter was picked up by a superior officer for suo motu revision, the additional commissioner. Now the suo motu revision order has been passed, reversing the appeal and restoring the order of confiscation. Under the Act, my lords, I have a right of appeal to the tribunal under Section 112, subject to and the recovery of the balance amount shall be stayed as per the provision if I deposit 20% of the penalty, which I have duly done.
You already paid the
I have paid the penalty. There's no dispute on that. The only issue, my lords, is now when I requested the officer to give me back the bank guarantees for two reasons. One is the section does not require me to give a bank guarantee as per Section 112. Secondly, the bank guarantee was given subject to the outcome of my first appeal before the Joint Commissioner, not subject to the outcome of the eventual appeal now before the tribunal. The officer refused to return the bank guarantee, saying, when you had given the undertaking before the High Court, you had said subject to the outcome of the appeal. Now the appeal you are seeking to prefer before the tribunal is also an appeal under the Act, so please keep it valid. So the only limited relief I'm seeking before my lords is that the bank guarantees he may be directed to return the BGs to me. My appeal before the tribunal anyway will be heard on merits, and that is an independent proceeding.
Yes. Now the order of the before the tribunal,
please,
you have sought for stay and made the payment.
Yes, I'll just take my lords. My lords, my lords would like to see the challan depositing the 20%.
No, is whether any condition is imposed.
As per the section, I'll just demonstrate.
Yes.
I'm only giving this because, my lords, on the last occasion, the book was not updated. 107. Section 107, my lords.
Yes. The book. Second appeal, isn't it?
Yes, 112 may be relevant. That's Section 112.
Section
112. Subsection 8, my lords. Oh, I think this is 112. So that would have been 107. My lords have that. Subsection 8. I'll just read, my lord. No appeal shall be filed under subsection 1 unless the appellant has paid. A and B may kindly, it may not be, it's not relevant in this case. The proviso may kindly be seen. Provided that in the case of any order demanding penalty without involving demand of any tax, no appeal shall be filed against such order unless the sum equal to 10% of the said penalty, in addition to the amount payable under the proviso to subsection 6 of 107, has been paid by the appellant. The proviso to 107(6), my lords, which I was given before, both these amendments were made by way of the Finance Act of 2025.
10% of penalty under.
Yes.
So there,
yes.
10 plus 10.
10 plus 10. So 20% of the penalty in all has to be paid. These proviso was introduced because originally the section only required me to pay 10 plus 10% of the tax.
There is no other condition imposed now.
Hmm.
And in fact, 1129 may kindly be seen.
Yeah.
My lords have it.
Yes, M. Kumar.
There is a deemed.
The only red flag is 129, 130
Yes.
means department.
I fully agree. In fact-
Department's eyes become wide.
Yes. To that I do bow down, because had it, in fact, that was a question I was asking myself. Had I been a dealer who was not trading, for instance, in Arikanak, had I suffered an order of adjudication, I filed an appeal, appeal was either allowed or dismissed. Let it be allowed. Again, SMR order was passed against me. If I were to file an appeal against that, would they ask me to give such a condition? That is the only question.
Now, the only point is, suppose the authority, appellate authority, despite this has some discretion, then they can impose a condition in the appeal. But here it appears that by virtue of this statutory, the stay must be granted on payment of that. There is no further power unless the authority itself feels subsequently on your application to revise that whatever.
It's, though this proviso talks of 10% of the penalty, my lords, don't talk about release of goods. It say recovery proceedings cannot be initiated for the remaining amount. It doesn't talk of release of goods, my lords.
The goods have already been released.
Goods have been released in pursuance to an order passed by this honorable court, Gulbarga bench.
Where is that order? Let us have.
That, my lords, is at page annexure F1, page 202.
Two zero
202, my lords. 205, para 4 onwards, can you be seen? May I read, ma'am?
Yes.
Learned counsel for the petitioners contended that P1 is willing to offer surety to cover the value of the goods, and therefore prays that the goods as well as the conveyance be released, subject to the outcome of the appeal filed by the petitioners challenging the confiscation proceedings. Learned Additional Advocate General submitted that if the petitioners are willing to offer security to the satisfaction of respondent number 1 in respect to the value of the goods and the penalty, the goods and the conveyance will be released. In that view of the matter, without going into the larger questions raised by the petitioners in this petition is disposed of on the following terms. 1, the impugned order dated so-and-so is kept intact. That was the order of detention, which of course ultimately culminated in the order of confiscation. 2, respondent number 1 is directed to release the goods as well as the conveyance held by R1 and 2 respectively on the petitioner number 1 furnishing sufficient security to the satisfaction of respondent number 1 to cover the value of the goods and the penalty thereon as prescribed. If the petitioners furnish the security within a period of 2 weeks from today, the respondent number 1 shall release the goods and conveyance within a period of 1 week thereafter.
Correct. Now,
yes,
it is the contention of the revenue that the release was conditional on giving a security. Now, since you have lost the appeals, your condition has not improved.
I just one subject.
Their contention is,
yes, I understand.
You have lost the appeals, so there's no change in circumstance. So that security has to continue while recovery is stayed because of deposit, and that provision 112, 107 only relates to stay of recovery. That's their contention.
And appreciate 2 points. One is, in fact, my first appeal was allowed. First appeal was very much allowed. In fact, the orders of confiscation were set aside. Immediately thereafter, of course, the additional commissioner in exercise of powers under section 108 took up the matter in suo motu revision, has reversed the order of the appellate officer and restored the order of confiscation. So in effect, I'm in first appeal before the tribunal because I'm actually appealing against the suo motu revision order. Secondly, my lords, the act does not make a distinction between the nature of the goods or how the appeal came to be filed. Had they chosen to do so, because I'll just take my lords also to 107 for a moment.
No, yes. One point appears to be is that the appeal was allowed. So the condition imposed was subject to the appeal. Now, the appeal was allowed, against which there is a revision. Suppose his first appeal was, both the appeals were rejected, it was a different matter.
These are only continuation. I can only submit this one. These are only continuation of the.
It's a revision order.
It's a revision order. Because since either the department will have a choice to challenge the order passed by the first authority by way of filing a writ petition before this honorable court, since the tribunal is not constituted, or suo motu revisional powers conferred under section 108. Here, my lords have exercised the powers conferred under section 108. Since the order passed by the first appellate authority is erroneous and prejudicial to the interest of revenue, that has been set aside and the order in original or the penalty order has been restored.
Can I just add one
Lords,
point?
it's only bank guarantee that is there, my lords. We cannot encash it now as of now since the matter is pending here. I may direct them to keep the bank guarantee alive, my lords, and take up the matter for disposal anytime.
I would, my instructions are to keep the bank guarantee alive. I have to always, the bank will not give me a guarantee unless that amount of funds is reserved in the bank. So on instructions, I'll give a bond. I'll file an affidavit also before my lord saying that if the balance amount is stable on my appeal being, in case it is dismissed, I will pay the balance amount. Secondly, my lord, I am not a fly-by-night dealer. In fact, I got the latest returns. Every month, both the petition number 1 and 2, I'm filing returns, paying tax. It's not a case that I'm going to not be within the confines of the respondents. And thirdly, my lord, I'll just for a moment, I'll just give it later. 120.
You're an SSC for how many years?
From 2017, my lord. From 2017, and I've just, this is the petitioner 1 and 2. Just to show, my lords, the first one at the top.
Operative portion of the order passed by this honorable court, my lord, does not talk about the bank guarantee to be restricted or the security to be restricted till disposal of the appeal. That is only a submission that is made, my lords. Page 205, paragraph number 4. That is a submission of the petitioner. And paragraph number 5 is the submissions of the learned AIG. Then, my lords, saying the operative portion of the order at page 6, my lord, at paragraph 6. The impugned order dated passed by respondent number so and so is kept intact. Respondent number 1 is directed to release the goods as well as the conveyance held by respondent numbers 1 and 2, respectively, on petitioner number 1 furnishing sufficient security to the satisfaction of respondent number 1.
There's one way out. You move the same court and seek for relaxation in light of whatever circumstance. Let the court consider.
That, my lords, I can seek it, but that condition which I had offered it, subject to the outcome of the first appeal, it would be, because at that time only my appeals before the appellate authority were pending. It may then fall from the court that your BG was given subject to the outcome of the first appeal. As my learned friend.
Where is that?
That is at paragraph 4.
It is a submission made. Submission made on behalf of the petitioner.
Condition imposed only says security.
Security to the satisfaction of respondent number 1 to cover the value of the goods and the penalty prescribed, penalty thereon as prescribed.
Otherwise, we'll keep it pending. You take a chance to seek for modification. Let the court see. Same court, you move the court.
My only thing, my lords, is in fact the BG was given to secure release. It is not for stay of the recovery.
Correct. So let's say that in the event the order under 130 is upheld.
Yes.
And your challenge to the revision order is rejected, and in the revision they pass an order against you. Then that recovery is taken care of by this bank guarantee.
But I don't understand the apprehension of the response. Where am I going to go? Am I a dealer who they're not going to be able to recover this money from?
No, that is a stand. That's a call you have to take, M. Kumar. In one matter,
why am I be treated different?
Correct. In one matter, I think Swiggy or Flipkart, I've observed that in case of regular SSCs, not persons, sometime you may have to treat them looking at their past record.
Maybe one of the right persons is in the wrong trade. Huh? One of the right persons is in the wrong trade.
No, but I'm saying if he's a SSC consistently, then you can you can look into it.
Let's have it on Tuesday or Wednesday.
You get instruction.
Because I can't strictly say that this was there in the mind of the learned judge while writing this order, because the operative portion of the order doesn't.
That is there, but if the department feels you have still an apprehension, that's a different matter. That will consider. Learned counsel for the petitioner submits that the condition of imposing bank guarantee when goods were released may be re-looked into as petitioners succeeded in the first appeal and the revision power exercised has been taken up in appeal. Full stop. It's further asserted that the petitioner is a regular SSC and has not made any default. And looking into the past history of the petitioner's compliance, the respondent authorities may reconsider insistence on bank guarantee for the sake of the revenue.
My lords, if my lords permit.
Third or fourth, my lords?
Relist on?
Third or fourth, man.
On fourth.
My submission that I can file a bond also to cover the balance may kindly be recorded also, because on instructions I've secured it. To secure the interest of the revenue, I'll file a bond.
One sentence, counsel for the petitioner submits that the
on instruction
value of goods would be secured by way of bond to be executed. Relist on. Now that's a call you have to take.
Listen, if I ask for instructions, there are only some instructions are, sir, this is only a continuation of a proceeding. If I ask them whether will you wait till the matter goes up to the Supreme Court, I have no answer. We get very limited answers from.
Okay, next date we'll consider.
Please.
You place with memo your history of your return, etc., etc., and that observation I made in that Flipkart or Swiggy, one of
I'll verify.
Saying that there what happened, I think they had made some raid, etc.
Oh yes, bundle, please. I think bundle, that is Swiggy only, yes.
In that I made some observation.
Please.
That
bundle.
That for some of the for the SSCs,
recovery of amounts in
the course of
for some how to treat an SSC who has a good track record is some observation.
That is recovery of monies, my lords, while conducting an inspection.
Where I've said don't treat every SSC like a night by fly by night.
Every 3 hours there has been some recovery that's deposit that is made.
27, Alesh Arji.
At the same stage.
In same stage. Yes. Yes.
My lord, petition is the individual assessing. My lord, notice has been served on 16 to page 21, my lord, 154 notice. My lord, after receipt of that notice, my lord, reply has been given on next page 22, my lord. After submitting my reply, my lord, this is my lord claiming exemption in section 54, long-term capital, my lord. My lord, after that, what is happened and what steps has taken assessing the authority, it's not come to the knowledge of the information has not provided to the SSC, my lord. My lord, the same thing has been mentioned in 154 notice, page 24, my lord. My lord, after receiving my reply notice, my lord, the assessing officer has said, my lord, the SSC has not, my lord, page 24, my lord. I may permit, page 24.
Yes.
Annexure D. On perusal of records, it is revealed that while passing order under section 143, read with section 147 dated 20/12/2018, the sale value was considered as a 2,27,12,860, whereas as per the sale deed, the sale value is rupees 2,77,12,860. Further, full value of additional cost amounting to rupees 28,37,500 was allowed without supporting documents. Notice under section 124 and IT Act 1961 dated 16/2/2020 was issued to the SSC to provide the assessing an opportunity to furnish his response. In response to the above notice, the SSC has submitted by letter dated 19/2/2022, wherein the computation of capital gain has been provided. It is seen from the computation sheet that the SSC has taken rupees 100 per square feet of the.
No, just 1 minute. Now, you claim that for the purpose of exemption, you have deposited the amount under that capital gain account.
Please,
if you have a material for that, we will see.
That please, my lord, because without my knowledge, my lord, this notice has been issued, my lord. And
What we
if
are saying, no, just 1 minute. What we are saying,
please,
that in case of
they're asking.
no, just 1 minute. In case of capital gain, if you have put that amount in the capital gain account, then you are exempt. If you can show that, we can close it here itself.
That opportunity has not provided.
So that here you show, we'll close it here itself.
My lord,
You find out.
I will find.
If you have.
My lord, this is the purchase value, and as per the assessing officer, further I may permit to read, my lord. What document they are required?
No, correct. 1 minute. If you have maintained that amount,
Please.
usually what they do is they maintain it under the capital gains account for 3 years or whatever. If that is there, you find out, then we can close it here itself.
Please, my lord, I will collect the document.
Find
I will
out.
place before this.
Council, it is noticed, isn't it?
Please, my lord, I'll.
Let him, if he has that, then we can close it here itself.
Please.
The peruse the order under 154 at annexure D. There's a reference that the SSC is stated to have deposited an amount of 2 crore in the capital gain account as on 30th April 2011 and has claimed exemption under section 54 of the Income Tax Act. However, the authority, in the absence of evidence of the same, has passed orders petitioner to clarify regarding the same. Relist on. When do you want?
Next week.
Next Tuesday.
Next.
Relist the matter same stage on next Tuesday.
28, Ashok K. Kulkarni.
Hearing for the petitioner, my lord. My lord, it's income tax matter.
I think Sammati Milons is there some difficulty. Lordships may kindly have it next Tuesday or Passover at 2:30.
You want to check?
Tuesday, please, Milons. Sammati appears in this matter.
General Counsel Sammati is directed to.
Milons has already accepted notice. Milons has some difficulty, Milons, now at 2:30 or Milons next Tuesday.
Very well.
Relist the
notice
matter.
pertains to assessment year
Same
15-16. It is barred by limitation. There's a division bench high court
Same
decision.
stage.
Same stage.
On Tuesday.
Pleasure.
29, Shiv Kumar, Akash Shetty.
My lord, this is an order under section 73 of the GST Act. Initially, for the notice issued under section issued in ASMP 10, I have filed reply. But it was partly considered. When the show cause notice was issued, it was not in the knowledge of the petitioner, and it was uploaded on the portal, and we could not participate in the proceedings. Meanwhile, bank attachment was made, and around 60 lakhs was debited from the account of the petitioner. Bank attachment can kindly be seen at annexure B at page 42. We pray for remanding the matter. We will not press for refund of the amount.
How much is recovered?
60 lakhs, my lord.
60.
60 lakhs. It is in my prayer. It is mentioned, but we will not press for refund unless a fresh order is issued.
So you are seeking for remand.
Yes, my lord. Yes.
On what is the matter?
Matter is difference between GSTR 1 and GSTR 3B. That is one issue. Second issue is excess availment of ITC, which is not eligible as per section 16(2)(c). Then third issue is short payment of GST, which declared as payable but not paid. Actually, we have paid that amount. It is we have shown in the returns filed in page 72.
Where is the order?
Order is at annexure A, page number 34, my lord.
First
34.
time, is it?
No.
Third, second time. It is at page number 34, annexure A.
You want to take some instructions, or we could?
It may be remanded, saying that show cause notice itself was not served.
The petitioner has sought for setting aside of the order in original at annexure A as well as form GST space DRC-13 B. Petitioners also sought for issuance of writ of mandamus to the respondents to refund an amount of 60,60,770 recovered from bank account of the petitioner. It is the case of the petitioner that the order in original under section 73 of the GST Act has been passed without benefit of any reply to the show cause notice. Petitioner submits that the petitioner did not appear before the authority nor made out a reply due to bona fide lapse which may be condoned. It is further submitted that grounds raised including short payment of tax in GSTR 3B as compared to GSTR 1, excess availment of ITC, short payment of GST declared as payable but not paid are matters which the petitioner would satisfy the authorities and the petitioner has material regarding the same. It's further submitted that as admittedly pursuant to the order impugned, the authorities have recovered tax arrears of 60,60,770. The petitioner may be afforded an opportunity to take his stand in writing by way of reply to the show cause notice by condoning the lapse in not participating in the proceedings diligently. The counsel for the revenue submits that the lapse on part of the petitioner is his own making and petitioner is liable for the consequences for not having participated in the proceedings. We'll stop next. It is a perusal of the order at annexure A would indicate that the order in original has been passed without benefit of any reply to the show cause notice. Admittedly, there has been a recovery of an amount of 60,60,770 pursuant to the impugned order. The assertions of the petitioner are that the grounds made out in the show cause notice would be explained if an opportunity is granted. Taking note of the contentions raised and the recovery of substantial amount of tax, it would be appropriate to accede to the request of the petitioner to afford an opportunity to take stand on merits. Accordingly, the order at annexure A is set aside. Matters remitted to the stage of reply to show cause notice. Petitioner to appear without further notice before respondent number 1 on
24th of March.
All contentions are
24th
kept open. Any attachment? No.
No attachment. When bank attachment was there, still exists.
In light of the order in original being set aside, the attachment of bank account to be rescinded by the authorities within 1 week from receipt of certified copy of this order. Yes. Date code.
30, serial number 30,
Please.
ASK.
Let's the petition. Let's ex-parte order under section 74 of the GST Act. Let's notices and the order has not been uploaded in the portal and have not physical service of the order and the notices also have not been done. Only on freezing of the overdraft and cash credit accounts, my lords, I came to know about the order.
Yes. First time.
Yes, my lords.
You want to check, you want to find out? Land Council Jeevan Niralgi accepts notice for the respondent. For all you will accept. Relist for respondents 1 to 4. 1 to 4. 1 to 4. 1 to 4. That we'll see. Relist. Entry hearing stage. An office to show the name of Land Council Jeevan Niralgi as appearing for the respondent.
31.
Please.
My lord, this is a service tax matter which was initiated based on income tax records. It's covered by the decision of Karnataka Chinmaya Seva Trust.
You are claiming exemption or?
No, man, they were not covered under service tax because they were purely into trading activity of computer peripherals.
Goods.
Goods. Yeah. So it's since they were not under service tax, no service tax return was filed. So purely on the basis of income tax records, the department has initiated.
They are not registered, not filed.
Yes.
Remitted back money.
Sometimes it becomes so monotonous.
Yeah.
Yes. My name may be shown.
Office to show the registry to show the name of Land Council Jeevan Niralgi as representing the respondents.
My lord, speed is has been on format.
No, I'm scared because I'm scared of this format because what happens that the application of mine, then your brain stops working and then mistakes will start coming.
No, there are several. Not considered.
Format 3 was applied late.
I had that only for bail conditions. The petitioner has called in question validity of the order in original at Annexure B, and the petitioner has also sought for appropriate directions for re-adjudication of the show cause notice. Let's go to Chinmaya Trust. Chinmaya Trust. The petitioner submits that the order in original would reveal that the authorities concerned have adjudicated upon service tax dues, upon liability to pay service tax on the basis of declarations made in the income tax returns for the financial year 15-16. Full stop. It is the submission of counsel for the petitioner. That petitioner was not registered under the provisions of the Finance Act.
Finance Act 1994.
1994. As the petitioner was a dealer in goods.
Goods, computer peripherals.
Consisting of computer peripherals, and a question of petitioner coming within the purview of service tax never arose. Full stop. It is submitted that this court, in matters where the service tax liability was adjudicated upon solely on the basis of information that is made out from income tax returns, has been remitting the matter back to the stage of reply to show cause notice, and has passed certain directions in WP 1154 of 2023, and in the present matter also a similar order may be passed. Repeat para 9 and 10. 9 and 10. There's no appeal is here, no? Is it?
No, it's an order in original stage.
9 and 10. Next. Accordingly, in light of the above, the order at Annex B,
page 46.
Is set aside. Set aside the authorities to take note of the observations made in the order dated 3/7/24 passed in WP 1154 of 2023 and connected petitions as extracted supra, in specific the observations of para 10 of the order as may be applicable. All contentions are kept open. Next, needless to state, petitioner is at liberty to make out fresh reply to the show cause notice. Petitioner to appear before the respondent number
1
without waiting for fresh notice on. Accordingly, petition is disposed.
34 urgent, 33, Srinivasa Gowda or 24th of March.
For the petitioner. Blood. In this matter, blood, in the year 93-94, blood, the layout is formed, blood, revenue layout. Before acquisition is of the year 2003, blood.
Purchased in the 2021-23. And this was acquired in the notification of 2003-2004, Arkavati layout. And all the subsequent purchases. And this one court matter, it was referred to the committee, Justice External Committee. They appeared before the committee. Committee recommended that general matter to consider all this, you make application before the BD under 38D. So that order was not challenged. When the committee order was not challenged, they accepted. Now we are seeking the matter for select the betterment tax and regularize. There is no such provision matter to acquire the land acquired and.
We'll continue at 2:30.
May make one submission, my lord. Serial number.
Serial number 56. Today afternoon I have got
Mentioning only at 2:30.
Again, submission, my lord.
75.
ಕಂಟಿನ್ಯೂ ಅಂತ ಮಾಡ್ತಾರ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ 230 ಇಷ್ಟು ಟೂನಲ್ಲಿ ಇಷ್ಟು 3 ಇದೆಯಲ್ಲ 4 ಇದೆಯಾ ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಮತ್ತೆ ಇದು 230 ಇದೆಯಲ್ಲ ಮೇಡಮ್ ಲಿಸ್ಟ್ ಒನ್ನಲ್ಲಿ 230 ಅಂತ ತೋರಿಸಿದೆ ಅದನ್ನು ತಗೊಂತಾರ
My lords, may kindly permit me to make a
My lord,
motion, my lord.
I am at serial number 75. There is a adjudication, GST adjudication order hanging on me. Request yourself to kindly take the matter on urgent basis.
Wait, let us see today.
Lordship kindly, my lord. Sorry, my lord. Day before yesterday, moved memo on memo, serial number 56 to yesterday. Since today my father's sermon is going on, serial number 56, motor vehicle tax matter, not to seize the vehicle. Informed AG as well, learned AG. Serial number 56. Sorry, put up.
Same one.
Connected matter, page 5, 2045 of 26.
AG accepts notice for response 1 and 2, Union of India's. So and so accepts notice for the same order.
My lord, may kindly permit me to make a mention, my lord. Serial number 66 in list 1, my lord. Past 3 days it has not reached, my lord, and there is no interim order. It is a section 9 arbitration petition, my lord. My lord, the matter has not reached the past 3 dates. My lord, at your convenience, maybe tomorrow at the fresh matters list, at the top of the list, my lords, may kindly place it, my lord. I humbly pray, my lord. I am sorry for the inconvenience.
Tomorrow in the fresh matters list.
Grateful, my lord.
Yes.
One submission, my lord. Fresh matters list, serial number 48 is also same. Identical.
Same to?
Same to the orders, my lord, second list orders. Pertaining to GST on affiliation fee by the colleges.
Serial number?
Serial number 48, my lord, 48.
48.
Yes.
I take notice in that.
I served on Nidalagi. Bangalore University, my learned friend is here. Fresh matter, 48.
Serial number 40?
8.
8.
6040.
List along with the batch of matters in serial number 1.
Yes.
Yes.
My lords recall.
Yes.
This is all GST on affiliation fee paid to university, my lords. Interim orders were granted based on the earlier coordinate bench decision. Last time I submitted a copy of that.
In
Now
which
recently,
matter?
I'll give a copy.
Here compilation, only in your favor only you can close. This Goa University has gone to Supreme Court.
Page number 1, my lords.
Yes.
This learned single judge order have been affirmed by the division bench. Page number 31. The earlier service tax regime order, my lords, page number 65 is a single judge order in the earlier service tax regime, which also have been upheld by division bench. SLP also was dismissed.
Now this single judge's order has dealt with all questions.
Sorry, my lords.
Single judge has dealt with all issues.
All issues. If my lord see page number 12, all questions are framed in para 11. Handwritten page number, my lords, on top, page number 12, para 11. Eight questions were framed. All have been answered in favor of the assessee. From page number 13 onwards, each issues have been considered.
Yes. Now the conclusion is that they are not
liable to pay GST on the affiliation fee or inspection fee, all that. In these batch of petition, it's only affiliation fee.
Affiliation fee.
Affiliation fee paid to university. And in this, even the board circular 11/10/2024 also has been held to be invalid. If my lord see page number 27 last. Order portion, my lords.
Circulars,
circulars,
17.6 and
11/10/24.
Now, in case of affiliation fee, any reference to the discussion?
My lords, if my lord see that page number 27 itself, issues 7 and 8. This is for basically for question frame for 7 and 8, but if my lord see that paragraph, page number 27, the paragraph above the heading order.
Yes.
As answered accordingly in favor of the petition by holding that affiliation fees, PG registration fees, admission fees, convocation fees, and other sums collected by the petitioner's university from the college students would not be exigible, amenable to payment of GST, and consequently the impugned show cause notice and orders deserves to be quashed.
Yes.
And next page, if my lord see page number 31, this order have been upheld by the division bench.
Yes. Against which?
Against division bench order, nothing has been filed. And in the division bench order, division bench refers to earlier writ appeal filed in case of service tax. Service tax also identical issue was there. Writ appeal number 856, if my lord see page number 32, para 3, there is a reference. Page number 32, my lord.
Yes.
Learned counsel for the respondent brings to the notice of this court that a coordinate bench of this court in identical fact situation and writ appeal number 856 of 22 disposed of on 37/24 has quashed the show cause notice calling upon the assessee to pay service tax on the income accruing on account or attributable to grant, renewal, withdrawal or denial of affiliation recognition.
Yes. In all these.
My lord, I had to make two submissions in this. There is some development on this. Lord, I just place on record division bench judgment of the my lord Madras the court. Lord, in this, my lord, this Goa University versus JCC GST Punjab, my lord, that compilation, ink page number 54. Your lordship may kindly see.
Page?
Ink page number that 54 in that compilation, my lord. That judgment is before the Honorable Apex Court now.
Service tax.
No, my lord, it is GST only. 54.
Page number 54 in the compilation.
54 of the compilation. It is GST only. That is before the, my lord, Honorable Apex Court, my lord. The Honorable Apex Court has issued a notice. That's one. And my lord, this judgment which I gave just, my lord, is of the Madras High Court. I request your lordships may kindly peruse few paragraphs of that. This is on reference because the 2-3 single judges of the Madras High Court have, my lord, given a different, expressed a divergent opinion. So, my lord, it was referred to a division bench. On reference, my lord, the division bench has answered against the assessee. My lord, I just, your lordships may kindly take to paragraph 7, my lords. 7. That is on page number 9. Page numbers are on bottom 9. It starts with the High Court of Telangana. When called upon to decide the issue of levying service tax affiliation fee collected by the university in so and so, held as below. Relying upon the constitutional decision of the Honorable Apex Court also, we are of the firm view that firstly the notification number so and so dated so and so cannot be made applicable upon inspection and affiliation fees charged by the first respondent university from the educational institutions. Secondly, since so far as inspection and affiliation fees charged by the first respondent university from the educational institutions has not been specifically exempted in terms of the Constitution Bench judgment in Mrs. Dilip Kumar and Company, the said benefit cannot be extended to the petitioners. As regards the two decisions rendered by the Karnataka High Court in Mrs. Rajiv Gandhi University of Health Science and Mrs. Bangalore University, which was heavily relied upon by the learned counsel for the petitioners. We are in complete agreement to the contentions raised by the learned counsel for the respondent department that the learned single judge of the Karnataka High Court, while passing orders in the aforesaid two decisions, has relied upon the provisions of Finance Act 1994, Section 66D, Clause 1 of Section 66D of the Finance Act, which in fact, first of all, stood omitted by the Finance Act 2016 with effect from 14/5/2016. Secondly, what also needs to be mentioned is that under the GST law, there is no such provision as a subclause 2 of Section 66D of the Finance Act. Therefore, we are inclined to respectfully disagree with the view taken by the Karnataka High Court in the aforementioned two decisions. Therefore, the said decisions are distinguishable in facts and law.
So it refers to the service law.
My lord, service tax law, where in the Finance Act, this services pertaining to an education where
Appeared for the revenue in that matter?
in I appeared in one of the matters.
You have not assisted the court properly.
No. That point of time, my lord, in the service tax, there was a specific exemption in the statute itself.
No, what I'm saying in this Rajiv Gandhi.
No, my lord, in writ appeal, my lord, I did not appear.
No, he is single judge who appeared.
Single judge, I appeared.
Single judge order, what is
I was
referred-
also one of them, my lord.
No, but prima facie, Madras High Court appears to be correct. Finance Act, if at all, refers only to service tax, isn't it?
Yes, my lord. No, distinction is this, my lord. The exemption contained under the provision of the Act has to be, my lord, a different interpretation, and exemption notification, my lord, is another interpretation. Lordship, I can appreciate, my lord. There is a scope for, my lord, some latitude to the courts to interpret it liberally, as far as statute is concerned. As far as an exemption notification is concerned, my lord, interpretation, my lord, differs.
That's why I pointed out last time, the division bench, when it affirmed, ought to have made a distinction.
Yes, distinction on this.
Earlier writ appeal is with respect to service tax.
Yes.
Then you have to apply your mind and then show that service tax and GST with
Or
respect to
parametry,
this,
my lord. That is not the case, my lord.
unless you record such finding, it will be there may be some difference in the nature.
There is a difference, my lord. There is a difference. There was a specific exemption without any exception in the service tax, because it was completely kept under negative list. Now here it is a notification. My lord, what happens is, if a levy is a, my lord, general rule, exemption is an exception. If, my lord, notification is issued to exempt, it becomes a burden on the assessee to demonstrate that, my lord, he falls within the four corners of that exemption. The burden is upon him. As far as statute is concerned, my lord, it is a very plain and unambiguous language which is used in the statute. He need not, my lord.
Correct, but now you will have to seek for review of the writ appeal and point out, that's all. It's up to you.
My lord, we may have to seek, my lord, a review of this. In view of this, my lord, this has come, my lord, very recently. I think, my lord, it was there or not. Now, your lordship may just, my lord, in the further paragraphs, your lordship may kindly how the lordships have, my lord, the lordship distinguished this 8.1, your lordship may. From the judgment cited above and from the reasonings given, we answer the order of reference as below. Affiliation to the colleges by universities prerequisite for any college to admit students for the course offered by the college. It is a prerequisite to admit student and conduct examination for them in respective courses. Only after affiliation is granted, the interface with the university and the admission of students in the affiliated college will commence. Imparting education commences from admission and ends on conferment of degree by the university to which the college is affiliated. In India, there are universities which are affiliating universities, and there are educational institutions which are stand-alone universities which admit students directly, conduct examination and confer a degree, but they are not permitted to grant affiliations to college. They are deemed to be universities. No doubt universities fall within the definition of educational institutions. However, the service of granting affiliation is not a part of admission of students or conduct of examination for them. So, my lord, exemption notification restricts the exemption to the, my lord, admission of students or imparting of, my lord, education or examination in the notification which they have extracted. The definition of service under section 2102 of the Act reads as follows, my lord, they have extracted even in that definition also this activity does not fall. The power to grant exemption from tax is vested with the government. On satisfaction of the recommendation of the council by notification, the government can exempt generally either absolutely or subject to such conditions as may be specified thereon any goods or service or both in exercise of power under section 11 of the Act. Accordingly, the service provided by the educational institutions to its students, faculty and staffs were exempted through notification so and so, which is relied by the petitioner university to seek exemption from paying tax for the affiliation fee collected by the university from colleges seeking affiliation from the said university. However, this exemption is not for all services rendered by the university, but restricted to admission and examination of students only. That notification they have extracted, the lordships may. Can you see that notification, my lord? On next page. By an educational institution to students, faculty and staff. By an educational institution by way of conduct of entrance examination, lordships may, against consideration in the form of entrance fee. Your lordships may, the next B, to an educational institution by way of transportation, etc., my lord. They all, my lord, are private parties who undertake to provide some services, my lord, transportation, canteen, etc., Now, that may not be applicable. My lord, 4, services relating to admission to or conduct of examination by such institution. Roman 4 is that, my lord, in the call. Now, my lord, they are extending this to an affiliation fee. Affiliation fee is collected for the purpose of conducting examination, my lord. That is their contention. That is on, my lord, analysis of the entire scheme, my lord. The Madras High Court has differed with the, my lord, other high courts. Lordships may, next paragraph, your lordship may can take, my lord, after that, 8.6. The exemption notification indicates that services relating to admission or conduct of examination by the educational institutions alone are exempted from service tax. Therefore, any services prior to admission of candidates or conduct of examination cannot be brought within the scope of expression services relating to admission to or conduct of examination by such institution. In the judgment of the Madurai Kamaraj University, so and so, judge has differed with the view, learned judge has differed with the view expressed by the advanced ruling authority, stating that there cannot be a narrow or pedantic interpretation to the word conduct of examination. In fact, my lord, in that earlier service tax, the writ appeal, the learned single judge had relied on this. So the reasoning of the learned single judge in the first matter, Rajiv Gandhi University or Bangalore University, is the, my lord, this Madurai Kamaraj judgment. The same reasoning, my lord, assigned by the learned single judge and affirmed by this division bench. 8.8. Contrary to that, in the case of so and so, which is later in point of time, the learned judge has taken into account the subsequent notification and observed that when there is no ambiguity in the language of legislation, taxing statute should be construed strictly while interpreting the exempting provisions. In the earlier judgment rendered in so and so, the learned judge had no occasion to consider circular number so and so, which clarifies the applicability of GST on the service of affiliation provided by universities to colleges. Paragraph 3 of the clarificatory circular by the Government of India, pursuant to the recommendation of the GST Council in its 54th meeting conducted on so and so, issued in so and so, reads as follows. My lord, this is the circular, my lord, which has been now set aside by the. This clarifies the position.
The single judge has set aside.
Yes, this one.
No, correct. But now what to do? I'll have to. Only...
My request is only to defer the, my lord, the hearing. My lord, let us see, my lord, what the Supreme Court takes the view. That could be more appropriate, my lord.
Correct, but now the division bench has also taken that same view.
My lord, just my lord, about 3 weeks, my lord, 4 weeks, your lordship may kindly postpone it. So that, my lord, whether division bench will be taken to the, my lord, SLP. But SLP, that one SLP on the same issue, my lord, I think notices have been issued, my lord. I think that we'll see some light on that, my lord.
Any of this in interim order, let us.
That is an interim order, they are protected.
In that case,
That's-
my lords, around 11 matters, interim order needs to be issued.
That will pass. What is the interim order in all the matters?
My lords,
my lord, 8.10, your lordships may kindly see in that judge.
8.10,
my lord, last paragraph. Last but one.
interim order ನೋಡಿ ಯಾವ್ದು?
That's
interim order ಯಾವ್ದು ಇಲ್ಲಿ ಕೊಟ್ಟಿದೆ? Yes.
My lord, thus it is undoubtedly clear that the fees collected for affiliation and for inspection of colleges applied for affiliation fall beyond the scope of service connected with the admission of students and conduct of examination. The illustration given by the learned single judge in so-and-so case, that admission of students by affiliating colleges controlled by universities while granting affiliation, and if the affiliation is granted for admitting 100 students, the college cannot admit even one student more. And therefore, the extended meaning should be given to the expression service in connection with admission of student is fallacious. The number of students to be admitted in the affiliated college is determined by the statute, namely the University Act, based on availability of necessary infrastructure such as building, teaching faculty, etc. Admission of students commences only after the affiliation is granted on satisfaction of required infrastructure. Any service provided for granting affiliation is independent of admitting student and conduct of examination. Therefore, extended meaning to the expression admission of student or conduct of examination is impermissible. This is, as a result, we hold that the view expressed in subsequent judgment, namely so and so, case declares the correct legal position, since the affiliation fee collected by the universities does not fall within exemption. Accordingly, the fee collected by the university from the colleges is affiliation fees is amenable to levy of GST. Thus, order of reference is answered. This is. So let there be some clarity on this, because
in fact, the Madras High Court has considered only the exemption notification. My lord, see the learned single judge order passed in GST. There were 8 issues. On section 7 and 9, it was held that it is not amenable to GST. Before going to the exemption notification, if my lord see, whether the activities, because my lord's activities has to be commercial in nature to levy GST. So that also has been held not in commercial nature, they are performing statutory function. Then they said, the learned single judge held that even section 7 and 9 is not applicable in case of a basic requirement to levy, to fall within the ambit of supply as well as to levy GST under section 9, the conditions have to be satisfied.
Let us see.
So Madras High Court has considered only the ambit of scope of serial number 66 of notification 12 of 2017, which is the exemption notification. That is one of the points which has been answered in favor of the assessor. Other 7, what has been considered now upheld by the division bench, has not been discussed by the Madras High Court, even the Telangana High Court.
You have no pleadings in your writ petition to that.
My writ petition, all these pleadings are there.
Let us see. Let us.
Let's say in respect of serial number.
Yes.
Let's say 1.2, 1.3, 1.5, 1.6. In this serial number 1.2, 1.3, 1.5, 1.6, then 1.14, 1.15, 1.16, and 1.21. All this interim order has to be granted, my lord.
Right? Interim order. Interim order.
Give a list of those numbers.
Other matters, it has to be extended, my lord.
And in my matter, my lord, fresh matter.
These are the interim orders passed in the
Serial number 48.
They are yet to be listed, or they are already on in the list.
Listed.
It is noticed that in this batch of petitions, an interim order of stay of the impugned circulars dated 11/10/24, 14/2/25 and 23/4/25 has been granted. full stop. Further, there is an order of restraint on the revenue directing them not to demand GST from the petitioners on the affiliation fee paid by the petitioners. Said interim order is extended till the next date of hearing. However, it is noticed that the benefit of the interim order does not appear to have been extended in the following cases, including in WP 6040 of 2026, which is now ordered to be now directed to be clubbed with the present batch of matters. The interim order passed on 9/10/2025 in WP 28327 of 2025 would be extended in all these petitions as well till the next date of hearing. Relist after 2 weeks.
4 weeks.
After 4 weeks.
In my matter, my lord, the notice is all to be ordered. 6040 is a fresh matter.
6040 and Council G1
1 to 3.
accepts notice for
My
response.
lord can treat it as part heard, my lord.
We'll see.
Your lordship have heard now.
Huh? 1 to 4.
1 to 3, my lord. 4 and 5 state.
G1 accepts notice for 1 to 3.
Yes.
AGF for 4 and 5. Mangalore University.
Mangalore University, my lord,
Council.
first batch also, my lord, wherever university is there, my lord, my name is kind of issue. Accept notice for
So far as respondent number 6 and Council Rajendra Kumar Sungay accepts notice for the respondent.
This matter, my lord, annexure B, my lord.
So far as matters wherever Mangalore University is arrayed as a respondent, third council Rajendra Kumar Sungay undertakes to appear, and accordingly office to show the name of so and so as representing the Mangaluru University. Yes.
And 6, my matter, my lord, annexure B, my lord. Dated 9 to 2016 is sought to be stayed. Annexure B.
No, there's already a common order staying the notification only.
But my lord, my cause of action is, my lord, February 2026.
No, correct. Those circulars itself is stayed,
Yes.
and there's a further prohibition to the department not to demand GST on the affiliation fee paid.
Prohibition on respondent number 7, university.
Yes.
That order is there.
Yes. Please read.
Madras High Court judgment is 5 days after.
Huh?
Madras High Court judgment is 5 days after judgment of this.
Division bench.
In fact, it was reserved before. It was reserved on 2/2/26 and pronounced on 10/2.
And in fact,
Our High Court is 5 days.
and in fact, Madras High Court takes note of the learned single judge order rendered in the service tax regime.
Yes.
Not considered the subsequent writ appeal order and SLP dismissal also. Those factors have not been considered. What they have distinguished is the single judge order rendered in service tax. That has been upheld in writ appeal. SLP also was dismissed.
No,
Those things have not been considered.
No, what they have said is, my lord, the judgments rendered in the context of Finance Act, that is service tax, are not applicable to the notifications issued under GST.
In fact, that negative list
They
was
have not said the.
Let us see.
66D.
But you have to, all of you have to catch hold of Raghavendra. Let us see. Yes.
Watch out.
These three.
For the petitioner's lordship.
Yes.
File a memo. Dishonorable court ordered the pass the order same land of site holders lordship on last date of hearing.
My lord, in these cases, my lord, Copies are not served, my lord. I will to look into the matter, my lord, because most of them, one copy served, my lord. In that is they are subsequent purchasers. There was the remaining case, my lord, the copies are not served. There. Look into the matter. One word.
The petitioners to serve copies of petition. No, you have to take notice, isn't it?
Yeah, remaining in
You have to take
first matter, ನಮ್ಮ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ, but copy is not served.
In
I served.
serial number, just serve it.
Today itself.
Learned counsel, Shri Anand undertakes to serve copy on counsel appearing for the BDA in serial number 1. Remaining matters, what is the array of respondents? Who's respondent number 1? In all matters.
All matters.
AGA accepts notice in all the matters for the first respondent. Then
Second commissioner, BDA commissioner.
how many are there? 2 to
5.
2 to 5 BDA. Huh?
2 to 5 BDA. BDA.
Learned counsel K. Krishna accepts notice for respondents 2 to 5. Copies of petition to be served. Relist after 10 days.
Yes.
Date may be fixed last year.
My date good. 16.
Right.
Yes. ಅವೆಲ್ಲ ಮೂರು ಅರ್ಜೆಂಟ್ ಅಂತ ಮೂರ್ನಾಲ್ಕು ಅರ್ಜೆಂಟ್ ಅದು ತಗೊಂಡ್ಬಿಟ್ಟು ತಗೊಂಡು
Serial number 2 passed overnight. Serial number 2 passed overnight.
Just already passed. ಜಾಸ್ತಿ ತಗೊಂಡು
The public action is dated 3/12/2000.
Yes.
I am the successful bidder on 19/12/2012 for a sum of rupees 54,10,800 rupees. Amount has been deposited. Then the sale deed was came to be executed in my favor in respect of the property in question on 35/90/2013. 5/4/2013 sale deed was executed. Then I went to the BBMP authorities for transfer of khata. I am told that it was already sold to some third party in the year 1978. Then thereafter, you last may kindly take at 14/1/2015. An alternative site was identified by the BDA, site number 1750 of bar 9 at page number 3. I agreed to purchase the said property. They said there is an excess land, I have to pay the excess price. I also paid the excess price also. Now after 15 years, they said we will not give the site and we will refund the money. For 15 years, they have kept a money of 54 lakhs.
Where is that allotment of alternative site?
Alternative site that you last may kindly take at page 49. Page 49 dated 30/8/23. ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆಯಲ್ಲಿರುವ ಸೋ ಅಂಡ್ ಸೋ ವಸ್ತು ತಿಥಿ ವರದಿ 1750 ಇದು ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟು. ಬದಲಿ ನಿವೇಶನ ಹಂಚಿಕೆ ಸಮಿತಿ ದಿನಾಂಕ 22/9/2018 ಅನೌಪಚಾರಿಕ ಟಿಪ್ಪಣಿ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ ತಂಗಸ್ವಾಮಿ ವೇಲು ಅವರು ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆ ಹರಾಜು ನಿವೇಶನ ಸಂಖ್ಯೆ 597/A ಅನ್ನು ಹರಾಜಿನಲ್ಲಿ ಖರೀದಿಸಿ ಹರಾಜು ಮಾರಾಟ ಕ್ರಯಪತ್ರವನ್ನು ನೋಂದಾಯಿಸಿ ದಿನಾಂಕ 4/4/2013 ಸ್ವಾಧೀನ ಪತ್ರವನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ಆದರೆ ಸದರಿ ನಿವೇಶನವು ಈಗಾಗಲೇ ಬೇರೆಯವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸದರಿ ಹರಾಜು ನಿವೇಶನ ಬದಲಾಗಿ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ದಕ್ಷಿಣ ಇವರು ಕುಮಾರಸ್ವಾಮಿ 1ನೇ ಹಂತ ಬಡಾವಣೆಯ ಹರಾಜು ನಿವೇಶನ ಸಂಖ್ಯೆ 1750/B ಅನ್ನು ಬದಲಿಯಾಗಿ ನೀಡಿ ಮೂಲೆ ಹರಾಜು ನಿವೇಶನ ಗುರುತಿಸಿ ಖಚಿತ ಅಳತೆಯನ್ನು ಈಡೇರಿಸುತ್ತಾರೆ. ಆದರೆ ಅರ್ಜಿದಾರರು ಸದರಿ ಮೂಲೆ ನಿವೇಶನವಾಗಿಲ್ಲವೆಂದು ತಿಳಿಸಿ ಹರಾಜು ನಿವೇಶ ಹಂಚಿಕೆ ಮಾಡುವಂತೆ ಕೋರಿರುವುದರಿಂದ ಸದರಿ ನಿವೇಶ ವಸ್ತುಸ್ಥಿತಿ ವರದಿ ಬಡಾವಣೆ ನಕ್ಷೆಯನ್ನು ಬಂದಿರುವುದಿಲ್ಲ. ಆದುದರಿಂದ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆಯಲ್ಲಿ ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರಲಾಗಿದೆ. ಇದು ಕಾರ್ನರ್ ಸೈಟ್ ಅಲ್ಲ ಅನ್ನೋದು ಒಂದೇ ಒಂದು ರೀಸನ್ ಹೇಳ್ತಾರೆ ಅವರು. ಐ ಆಮ್ ರೆಡಿ ಟು ಪೇ ದಿ ಎಕ್ಸಸ್ ಅಮೌಂಟ್. ಇಟ್ ಇಸ್ ದಿ ಇಂಟರ್ಮೀಡಿಯೇಟರಿ ಸೈಟ್. Then you last may kindly quote page 50. Page 15 I was directed to execute the cancellation deed in view of the allotment of alternative site. Kindly see annexure Y page 50. ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆಯ ನಿವೇಶನಕ್ಕೆ 597ಕ್ಕೆ ನೋಂದಾಯಿಸಲಾದ ಹರಾಜು ಮಾರಾಟ ಕ್ರಯಪತ್ರವನ್ನು ರದ್ದುಪಡಿಸುವ ಬಗ್ಗೆ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆ 1ನೇ ಹಂತದ ನಂಬರ್ 597/A ಹರಾಜು ಮೂಲಕ ಶ್ರೀ ತಂಗವೇಲು ಆದ ತಮಗೆ ಹರಾಜು ನಿವೇಶ ಸ್ಥಿರೀಕರಣ ನೀಡಲಾಗಿದ್ದು ಹರಾಜು ಮಾರಾಟ ಕ್ರಯಪತ್ರ ನೋಂದಾಯಿಸಲಾಗಿರುತ್ತದೆ. ಈ ನಿವೇಶನವು ಈ ಹಿಂದೆ KR ರಾವ್ ಅವರು ಹರಾಜು ಮೂಲಕ ಪಡೆದಿದ್ದು ಕ್ರಯಪತ್ರವನ್ನು ಕೂಡ ನೋಂದಾಯಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ತಮಗೆ ಬದಲಿ ನಿವೇಶನದ ಹಂಚಿಕೆ ಸಮಿತಿಯ ಸಭೆ ದಿನಾಂಕ 22/9/18 ತೀರ್ಮಾನವಾಗಿರುವ ನಿಯಮಾನುಸಾರ ಬದಲಿ ನೀವು ಹಂಚಿಕೆ ಮಾಡಲಾಗುವುದು ಹಾಗೂ ನಿವೇಶನಕ್ಕೆ Then you last may kindly my representation dated.
Now, what is the date of annexure X?
Annexure X page 38-23. ಐಡೆಂಟಿಫೈ ಮಾಡ್ತಾರೆ, ನನಗೆ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ, ನನಗೆ ಎಕ್ಸಸ್ ಅಮೌಂಟ್ ಕೊಡಿ ಅಂತಲೂ ಕೇಳ್ತಾರೆ, ನಾನು ಕೊಡ್ತೀನಿ ಅಂತಲೂ ಒಪ್ತೀನಿ. ಅದನ್ನೆಲ್ಲ ಫಾರ್ಮಾಲಿಟೀಸ್ ಎಲ್ಲ ಮಾಡ್ತಾರೆ. ಆಫ್ಟರ್ 5 years ಇದನ್ನು ಕೊಡಕ್ ಬರಲ್ಲ ನಿಮಗೆ, ವಿ ವಿಲ್ ರೀಫಂಡ್ ದಿ ಮನಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಆದ್ರೆ 10 ವರ್ಷದ ಹಿಂದೆ ನನಗೆ ದುಡ್ಡು ತಗೊಳ್ತಾರೆ. 2012 is the date of action. 54 lakhs has been received. Sale deed was executed. Possession certificate has been issued. While taking the Khata certificate, it was found that it was already sold to some third party else.
I'll direct the police to file an FIR for cheating directly against the commission. Here, what is this? Is this the way you treat BD allottees? And you get it cancelled after a representation made in your board resolution and unofficial note saying we will give you an alternative site.
May I just
After which only didn't he cancelled it?
May I just submit?
You're a public authority, isn't it?
May I just submit, my lord, as to why that has been so done, my lord. Auction, my lord, is held under the corner seat allotment rules, my lord. I request your lordships to kindly come to the corner seat
No,
allotment.
those legal technicalities may be there. I'm not disputing. But I'm saying, look at the justice at your hands. You're a public authority.
I understand, my lord.
There is a grievance, isn't it? Now, how are you going to address that grievance? There must be some manner of addressing. Now, you can't give money after so many years. What is the real estate appreciation? He bid for it in an open auction.
Please.
With the hope
Confirm.
I'm investing in some real estate at whatever price. Now that, first of all, you shouldn't have put it to auction because you were aware sale deed has been executed. How did you put it to auction? God alone knows. Did you initiate departmental inquiry against your officials? No, we don't know. The material is not placed. You make a representation to him. You cancel it. We will give you an alternative site. Cancellation is done after this representation to him. Sale deed is executed. He has paid stamp duty. And now after so many years, you say it is not permissible after 5 or 6 years. You say it is. Now, who have you allotted that intermediate site? Let me find out.
The intermediate site, my lords, what has been identified, my lords? That, my lord.
Who has it been allotted to?
Nobody has been allotted.
No, they would have allotted. You don't know.
Please.
You don't know.
I'll find out, my lord. I'll place on
You
record.
find out.
But may I just submit this, my lord? The reason why we said that, my lords,
No, that may be so. I'm not disputing. See, legally.
the rules
know,
came
under
in the way, my lord.
Maybe, I'm not saying. But how are you going to solve this problem?
I understand, my lord, the
So
fact, my
it's
lord, that
up to
appreciation
you.
of price, I understand, my lord.
No, it's up to you. You do it. Otherwise, I'll directly direct for registration of an FIR for cheating. Let it come out in the headlines of the newspaper.
My lord, as with respect to that part, my lord, having put a property already having been sold for auction, my lords, whatever directions your lordships gives us, my lords, will go with.
I am not going to. I'm not. However, the court is not bothered of the lapse between you and your official. That is your internal matter.
Please.
Vis-a-vis a third person, justice must be done in the hands of a public authority. You are not some house building cooperative society, isn't it? So you will have to do justice to him. If your rules don't permit, treat it as an exception because of your lapse and do justice. How it is to be done, I am not going to impose. But it doesn't look nice for the BDA to behave like this. Prima facie, whatever restriction may be there, you must find a solution to this problem. If there is a fault on the part of the petitioner, I would appreciate any stand taken by you. Where an innocent person who wants to buy an auction site, as is where his condition comes, where do you place him now after 5 years, 6 years? It's something for you to reflect upon that, sir.
15 years.
It must have been there must have been some reason, my lords, as to why an auction site got re-auctioned once again. There must have been some genuine mistake. But my lord, the reason as to why, even though there were, my lord, steps
No,
taken.
but then why did you promise him by way of a resolution that we are going to give you an alternative site?
Alternate site, my lords, is given under Rule 11A of the
No, okay. Why
allotment
did
site.
you promise him by way of your resolution?
That is where, my lord, is something surprising, because under Rule 11A, my lords,
No,
an
I'm
alternate site is given, my lords.
He is not bothered, nor is the court bothered of your rule. How did you make a representation to him that you are going to give an alternative site? After that representation, you get the sale deed cancelled.
Sale deed is not yet cancelled, my lords.
Good then. Like you give him that site. You give him that
Fair
site.
auction is in there 98, my
Now
lords.
you cancel the earlier allotment now. Amongst both of them, you cancel it now.
I'll obtain instructions, my lords. I'll obtain instructions.
How you are going to solve it? You can't compound it now. What has happened is happened.
I understand.
We don't want to do a post-mortem. Now you give alternative site in HSR layout for some village acquisition. Give him alternative, make it under the orders of the court. We will pass an order looking at what has happened in this case.
They have identified and received the money.
I'll obtain instructions, my lord.
If you want the court to make an observation to facilitate you to take some action, we will do it, looking into the justice of the case.
I request, my lord.
But you have to come forward.
I understand. May I request, my lords, to have it next week. I'll obtain instructions, my lord. Place material on record as to the board resolution as to on what circumstances it was
Correct,
passed.
but
And I'll, my lord, I'll assist your lordships. If any observations can then be made, your lordships can make the observations. It will be convenient, because, my lords, I am not, my lords, arguing the matter.
No,
I am with your lordships when your lordship says some justice has to be done, because it was an auction sale. He has paid the entire money, my lords. But the reason as to why such an endorsement was issued, my
No, so
lords,
you show the way. You show the way. Under is there any provision, etc. Then we will facilitate exercise of power to do justice. But that you have to discuss, and then you get back.
I'll obtain instructions, my lord. Because, my lords, my understanding, my lord, limited understanding, my lords, is I'll stand corrected, my lords, if I'm wrong. The rules don't permit us. Possibly with your lordship's directions, we will be able to do it, my
No,
lords.
that's why. So that you first
Obtain instructions.
In principle, in principle, the authority must come forward one step, saying that yes, there is something. We leave it to the court, and then you show under what provision, alternative, etc. We will see how we can, using 226, enable a closure to this. That's all.
Please, my lords. Any date your lordships may kindly please.
Now, may I request this honorable court to keep this site, not to auction the property. This alternative site which was identified to allot.
Not already allotted, my lords, an interim order may kindly be passed.
They
I have no
cannot say
objection.
that. Till today,
Allah.
nothing has been done.
I'm not aware of it, my lords.
Then-
If not already allotted, my lords, we will not allot it any further. But as on date, I am unaware, my lord, if it's allotted or not. I do not want to make any.
That's an intermediary site, is it?
Please, 1750F bar B,
No, is that intermediary or corner site?
intermediate site.
The correct dimension report.
Kumaraswamy first stage, Kumaraswamy layout first stage, site number 1750 bar B. Pay annexure X.
That is also an auction site, my lords. The letter says is an auction site. An auction site, my lord, initially auction sites were only corner sites. Now they are also intermediate sites. I will obtain instruction on this also, my lord, if it's intermediate or corner site.
Taking note of the peculiar facts of the present case, and in light of the fact that petitioner was the successful bidder to an auction site, which site, according to the respondent BDA, was already auctioned at an earlier point of time, and taking note that the Bangalore Development Authority had offered allotment of site number 1750 bar B.
I'm sorry, my lord. I'm sorry, my lord, I'm interrupting. We are not yet offered that site for allotment to the petitioner, my lord. Petitioner has identified that site, and my lord, a correct dimension report might have been called for. A correct dimension report is not called for in the name of any particular individual, my lord. A formal allotment, my lord, is only done by way of an allotment letter after approval of the commissioner, my lord.
Is annexure Y?
Annexure Y.
Kindly take annexure R, page 43. Page 43, annexure R. They specifically said, ಅದರಂತೆ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆ 1ನೇ ಹಂತದ ಹರಾಜು ನಿವೇಶನ ಸಂಖ್ಯೆ 597A ಈಗಾಗಲೇ ಬೇರೆಯವರಿಗೆ ಹಂಚಿಕೆಯಾಗಿರುವುದರಿಂದ ಈ ನಿವೇಶನಕ್ಕೆ ಬದಲಾಗಿ ಕುಮಾರಸ್ವಾಮಿ ಬಡಾವಣೆ 1ನೇ ಹಂತದ ನಿವೇಶನ ಸಂಖ್ಯೆ 1750 ಬಾರ್ ಬಿ ಅನ್ನು ಬದಲಿ ನಿವೇಶನವಾಗಿ ಹಂಚಿಕೆ ಮಾಡಬಹುದಾಗಿರುತ್ತದೆ. They cannot interpret something more than that.
No, I'll just correct it. My lord, this is an unofficial note generated by the engineering section without being called for any such report from the allotment section, my lords.
No, that's between you and your referee.
I understand, my lords. What I am trying to submit, my lords, if your lordships want to pass an interim order, my lords, I am not coming in the way, my lords. I'm only, my lords, I am only submitting this. This is an unofficial note generated by the engineering section without being called for one by the allotment section, my lord. An allotment is done only pursuant to an allotment letter issued by the allotment section. Lordships, I am not coming in the way of an interim order, my lords. I don't want to say that because I understand where I am, what I am standing, what mistakes I have done. I understand that, but this letter cannot be construed in a manner in which it is not meant to be. Is all that I am saying.
Time, comma. The respondent BDA is required to address such grievance. Next. Taking note of the unofficial note at annexure R, wherein the engineering section has made a proposal that site number 1750 bar B,
Kumaraswamy first stage.
Kumaraswamy layout first stage may be considered being vacant may be considered for allotment in order to ensure that the said site is not allotted by BDA to any other allottee. There will be an order for respondent BDA to maintain status quo regarding possession and creating of third-party rights with respect to site number 1750 bar B, first stage Kumaraswamy layout till the next date.
Please.
Next. The Commissioner BDA may look into the peculiar facts of this case and explore possibility of redressal of grievance of the petitioner. Such direction is required to be passed as the respondent BDA is prima facie at fault for having put to auction a site which, according to the respondent BDA itself, was already auctioned. Please relist the matter. And you must come hard on your officials, all engineers, whoever, who do
Observations,
this,
my lords.
who
I
do this
understand.
suo moto.
Observations, my
etc.
lords, by my lords will definitely help, my lords. I don't want to, in such matters, I don't want to really argue the matter. I would rather assist your lordships in passing correct orders. I understand the grievance of the petitioner, but I'm with the petitioner as far as the grievance is concerned, because real estate valuation prices goes up beyond any particular percentage of normal banking also. So I understand the grievance, but my lord, our difficulty was
Hundreds
the
of-
rules came in the way. If your lordships under 226 passes an order, my lord will definitely comply.
Hundreds of acres of BDA land notified, award passed. You allow all real estate people to put up mansions and buildings. Possession is not taken. After 30, 40 years, they come seeking lapse. You have not compounded nor fenced any of the properties which you have paid to the landowners.
Correct.
Yes, miss.
Oblige. Any date may kindly be fixed.
Date.
Please, oblige.
3 and 4, my lords, my learned senior friend Ravi appears.
Yes. Today is not the tax day.
Please, please, my
The
lord.
tax day. Where's Raviraj? Ah. Yes.
It actually is covered by the judgment, my lords.
Lords, against that order, my lords, we filed a review petition. Lords, that is pending. Lords, your lordships may kindly have it after the review petition is disposed of.
Some interim relief at least.
Lords, this is 119 2B, my lords. There is no interim prayer in this.
So I was not aware of that much. I will await the orders, my lords, in the review petition.
Relist after 2 weeks.
Lords, after 3 weeks.
After 3 weeks.
Please.
The Lord Council Dilip.
The delay, my lords, the problem over here, my lords, the competent authority has taken over the assets of IMA, my lords, that is on the Ponzi scheme, my lords, they had taken money from all the depositors, my lords, and they had inflated the rates, my lords, and to show high profits, my lords, they had filed returns showing more income. The scam was, my lords, uncovered, my lords. Now the competent authority has taken over all the assets of the assessee. Now they want to file revised return by giving actual figures. Now by virtue of revised return, they will get refund. That they are entitled, because they cannot file the revised return. They don't fit into the definition under representative assessee. That is the reason, we filed a review petition before the single judge in the first case. Once that is passed, then it will be taken.
Two submissions, my lord. One, my lord, the kingpin of the Ponzi scheme, who's the author of the Ponzi scheme, my lords, taking the money from the depositors, has exaggerated his income, my lords, and he has paid the income only, my lords, to lay a bait for other depositors to follow.
That may be
It is nobody's case that it was the actual income that he has paid. So now all that I'm saying, my lords, is that the money that has been paid as income tax has come from the depositors' money. So let the money be given back to the depositors, and I'll be able to establish that it was an exaggerated claim, for which, my lord, we have the investigation reports, and even they are not disputing. On a hypothetical ground, my lords, that I do not fit into the bracket, my lords.
Representative assessee, my lords. That is our difficulty.
List after 3 weeks at request made on behalf of the respondent. We club these both.
Please.
Seal number 4, we clubbed along with seal number 3.
Keep you blessed.
Let's appearing for the petitioner.
Yes. So there, we could consider and then send him back to file an appeal insofar as release of goods and conveyance on same terms as per the order passed in
The 25%.
25 and 75 indemnity bond.
Indemnity bond, well, that's, all the officers are here asking me how we are accepting indemnity bonds. It will be difficult, Malaj, that is. but I can't say anything else.
Finally, the confiscation order is still to be determined. Let us see. But you will have to have some other solution in law. The petitioner has called in question the validity of the order at annexure A dated 11/12/2025.
But in this matter, my lords, they are ready to give a bank guarantee. Amount is very less.
Full stop. Annexure A is the order of confiscation of goods and conveyance.
Total fine amount levied is only 4,55,000.
Dated 5/1/2026. Full stop. Petitioner has raised various contentions, including procedural violations. Third counsel for the revenue would submit that the detailed findings made in the order in the context of the grounds raised are factual in nature and raise a mixed question of fact and law, and that the appropriate remedy for the petitioner would be to challenge the order at annexure A before the appellate authority under section 107
107
of the Act. Full stop. Though petitioner has raised certain procedural violations, however, the adjudication as reflected in the order presents mixed questions of fact and law, and it would be appropriate for the petitioner to avail of the statutory appellate remedy to challenge the order at annexure A. Next. However, in light of the request of the petitioner for release of conveyance and goods, and taking note of interim orders passed in certain writ petitions filed relating to challenge to confiscation orders under section 130, it would be appropriate to release the conveyance on terms while stipulating that such release would be subject to final orders to be passed in the appeal to be filed by the petitioner. Full stop. Next, while we relegate the petitioner to avail of the substantive statutory remedy, however, insofar as the request for release of goods and conveyances, the following order is passed. Now he would pay 25% and remaining
bank guarantee for
for the remaining petition. Following orders passed. 1. Petitioner to pay 25% of the amount as determined in the order at annexure A as regards value of the goods. B. Petitioner to furnish bank guarantee for 75% of the value as determined in the order of confiscation. Full stop.
Your Lordship, the order and the SOCOS notice has not been uploaded in the GST portal of the petitioner. If such order was uploaded, then only we can able to prefer the appeal level. So that direction can be given to upload the order in the GST portal level.
My lords will permit them to file it manually also, my lords. Within 2 weeks or 3 weeks, whatever time my lords are granting to file an appeal. A liberty may be reserved to file it physically also.
Yes, lords. That can be also permitted.
Within,
So that they don't have some technical problems.
the goods and conveyances would be released on petitioner making payment and executing and furnishing bank guarantee in terms of the directions made above. Next, insofar as the substantive legal challenge to the order at Annexure A which the petitioner intends to continue, if the appeal were to be filed by the petitioner within a period of 2 weeks from date of receipt of certified copy of the order, the same may be taken up by the appellate authority without raising any objection on the point of limitation. Such order is passed taking note of pendency of the matter before this court. All contentions are kept open.
Will also, it can be mentioned that the physical submission of the appeal can be taken up because there is a technical procedure that was
Appellate
followed.
authority may accept the appeal if filed physically. Yes. As it is submitted that petitioner may not be in a position to file appeal in digital mode as order and show cause notice have not been uploaded on the portal.
Yes, sir.
Yes.
Much okay.
But petitioner blood is grandma. Who have you served?
Lord Mr. Krishna, Lord. K. Krishna. WP 46495. Okay, sure. There is a registered sale deed executed by the BDA. And the BDA issues notice not saying that you have encroached this site. There is a registered sale deed in favor of my grandmother.
At
Annexure A, Lord, is the notice. It says it's a final notice. But the latter portion says not 5 days to reply. But earlier they issued a notice. I said, give me some time to reply. But I realized there's something fishy going on there. This notice comes, they say 5 days to reply. The last portion says within 5 days, I'm supposed to remove everything from the property.
Where is the allotment?
No, I'll straight away take my notes to sale deed notes, which is at page 36. It was initially given to my grandfather. My grandfather died, therefore sale deed is executed in favor of my grandmother.
This was an allotment.
Yes, Lord. Lease cum sale agreement was executed. Page 36, not is the sale deed. In 2007. But the details of the property is mentioned, not there's a schedule at page 41. ನಿವೇಶನ ಸಂಖ್ಯೆ 450 ಸಾರಕ್ಕಿ ಬಡಾವಣೆ 6ನೇ ಫೇಸ್ ವಿಭಾಗದಲ್ಲಿರುವ so and so. If my lords comes back,
same site.
Same site, Annexure A, page 18. But the first paragraph. ಮೇಲ್ಕಂಡ ಪ್ರತ್ so and so ನಿರ್ಮಿಸಿರುವ ಸಾರಕ್ಕಿ 6ನೇ ಫೇಸ್ ಜೆಪಿ ನಗರ
Page 56, my lord.
Yes. Yes.
My lord. ಮೇಲ್ಕಂಡ ವಿಷಯ ಸಂಬಂಧಿಸಿದ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ವತಿಯಿಂದ ನಿರ್ಮಿಸಿರುವ ಸಾರಕ್ಕಿ 6ನೇ ಫೇಸ್ ಜೆಪಿ ನಗರ 6ನೇ ಫೇಸ್ ಬಡಾವಣೆಯ ನಿವೇಶನ ಸಂಖ್ಯೆ 450ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಜಾಗವನ್ನು ಅನಧಿಕೃತವಾಗಿ ಒತ್ತುವರಿ ಮಾಡಿಕೊಂಡು ಬಳಕೆ ಮಾಡುತ್ತಿರುವ ಉಲ್ಲೇಖ ಪತ್ರದಂತೆ ಈ ಕಚೇರಿ ದೂರು ಸಲ್ಲಿಸಿದೆ. So not the 450, he starting construction while encroaching the adjacent site. Therefore, my lord, notice was issued to remove that encroached portion.
In excess of the allotment.
Excess of the, apart from the 450 site, he constructing the adjacent, encroaching the adjacent site.
But please see page 18. It does not say so.
Now the my lord, the
Page
notice was
18, first
issued.
paragraph.
He sought, and as per annexure N, my lord, page 58, they have sought 15 days time. Let them, this treated as a notice, my lord, let them to.
No, we could clarify if this is the stand.
No, I
that
sought the instruction, my lord,
correct,
from
if that is the stand,
Yes.
we'll say that you go ahead with it. Now they will, this notice will not be construed to be in any way impinging upon your rights with respect to the property conveyed to you. This one you participate. We'll clarify that much.
But can I please turn to page 18 for a moment?
Page
18, the impugn notice.
18.
18. Now please see the first paragraph.
No, now we'll limit it to that. We'll construe.
Insofar as the adjacent land is concerned, but I'll be entitled to seek for marginal land which is adjacent
That I
to
don't
that.
know. That's
No,
between
my lord,
you.
I'm only saying, Lord.
That's correct.
Whatever
That's
they're going to do, let them do in accordance with law. That is all that I'm saying.
Correct.
That is all.
We will clarify.
Please.
That annexure A will not be applicable insofar as the property that is sold
Very
to
well.
you by a sale deed.
Yes.
Insofar as the notice that they can proceed in accordance with law.
In accordance with law, my lord, I may be given an opportunity to submit my reply to that as well. Please.
We can dispose it off only.
Yes, my lord, let them to, my lord, the annexure A is the notice. My lord, let them to give the reply with the supporting document for showing that the adjacent site, they have the title. And my lord, we will consider, and they are hearing that, my lord, we will proceed further.
So we can dispose it off.
Lord, I'm only saying 450, I'm the owner. Impugn notice is with regard to 450.
So we'll limit it in light of the stand.
Very well.
We'll limit it to property other than 450. The petitioner has sought for setting aside of the final notice dated 23/2/2026 issued by respondent number 2 who is the engineer of the BDA.
My lord should permit me to submit a reply, my lord, to the notice in respect of the rest of the portion.
Yes.
Because I'm also seeking for allotment of that marginal land. That's why.
The notice at annexure A is to the effect that there was a complaint received regarding encroachment of a site, and upon examination the authorities have issued a notice calling upon the petitioner to make out a reply, and in the absence of any reply to said notice, the authority had intended to take action to evict the petitioner. Petitioner would point out that the sale deed was executed on 12th October 2007 by the respondent BDA in favor of
Saraswati, my lord, my grandmother.
Srimati Saraswati, who stated to be the grandmother of the petitioner. It is submitted that the schedule, the description of the property in the schedule to the sale deed is identical to the description of the property in the notice at annexure A. Full stop. Accordingly, it is submitted that the notice has no legs to stand. Full stop. Learned counsel for the respondent BDA upon advance notice submits that the notice at annexure A must be read in conjunction with the notice at annexure M.
Annexure, yes,
M.
ma'am.
And
Annexure
that and that the proceedings regarding alleged encroachment are with respect to land apart from the extent of land
Site
that
number.
was sold to the grandmother of the petitioner in terms of the sale deed at annexure F. Full stop. Further submitted that the notice at annexure A to be construed to be in furtherance of annexure M and to be treated as a show cause notice and would be limited to the alleged encroachment beyond the limits of the property site number 450 with respect to which sale deed has been executed to the petitioner's grandmother. Otherwise M only, A we can, you can, A will have to go.
Let them M notice.
A we
reply
can say, next. It is however noticed that the notice at annexure A is vague and bereft of specific details. And accordingly, in light of the stand of counsel for the BDA, that the intention is to elicit reply of the petitioner in terms of annexure M notice.
Let them to court order.
Now I am giving a finding. It would be appropriate to set aside the notice at annexure A while observing that BDA is at liberty to proceed further pursuant to annexure M. The identity of the property not being in dispute insofar as the property with respect to which sale deed at annexure F has been executed. Needless to state, the proceedings for alleged encroachment as noticed in the notice as noticed at annexure M would be only with respect to the extent of property beyond the extent as conveyed to the petitioner's grandmother through sale deed at annexure F. All contentions are kept open and respondent BDA while proceeding further to annexure M is to afford procedural afford opportunity of hearing to the petitioner and follow procedure as per applicable rules.
Let them to they file the objection within a time limit.
The petitioner to make out his objections to annexure M within a period of 2 weeks from date of receipt of certified copy of the order. All contentions are kept open. Accordingly, petition is disposed of in terms of the above.
Lord, can I seek for 4 weeks? What has happened is
4
both
weeks.
his parents, Lord, are no
4
more.
weeks.
Great. Great.
The previous occasion, my lords had
Yes.
My lords, on the previous occasion, my lords had granted an interim relief wherein I was supposed to deposit a sum of 10 lakh rupees and provide immovable property as security, my lords. These are wherein without concluding 129 proceedings, directly 130 proceedings were initiated, my lords. Despite producing sufficient materials, my lords, for them to secure their interest. It's been more than a month since I've
I was able to secure an interest from my lords, but it looks like the revenue is not ready to release my goods, my lords. If I may make a submission, my lords may kindly direct me to pay 25%, what my lords have been doing since yesterday and today. I'm ready to deposit 25%. Let the goods be released. Anyways, I've provided an indemnity bond. Let this writ be pending, my lords. If I may pass on a memo of calculation, my lords.
Yes. Yes, Kumar.
Please. Lords have been consistently passing this order, my lords. I would just like to read two paragraphs only to those show the conduct of the petitioner in this matter. Annexure A1, my lords may kindly see.
Page
A1, page 41. That's why I've been insisting on all this Arcanet dealers and Arcanet matters, my lords. My lords will appreciate in this matter. A1, page 41, my lords. In this, in fact, a counter has also been filed in this. Pleadings are complete. Lords, my copy is not very legible. I'll try to read it from whatever is available, my lords. ದಿನಾಂಕ 23/11/2025. My lords have got it, man. ಒಂದು ಭಾನುವಾರ ವಲಯ 2 ರಾತ್ರಿಪಾಳ್ಯದಲ್ಲಿ ಭದ್ರಾವತಿಯಿಂದ ಶಿವಮೊಗ್ಗ ಬೈಪಾಸ್ ರಸ್ತೆ ಕಡೆಯಿಂದ ರಸ್ತೆ ಜಾಗೃತಿ ಕಾರ್ಯ ಬರುತ್ತಿದ್ದಾಗ ಸುಮಾರು ಮಧ್ಯರಾತ್ರಿ 12 ಗಂಟೆಗೆ ಸಮಯದಲ್ಲಿ ವಾಹನಗಳು ಸಂಚಾರ ಸಂಪೂರ್ಣ ಸ್ಥಗಿತಗೊಂಡಿರುತ್ತದೆ. ರಸ್ತೆಯಲ್ಲಿ ಸಂಪೂರ್ಣ ಖಾಲಿ ಇರುವುದರಿಂದ ದೂರದಲ್ಲಿ ಬರುವ ವಾಹನಗಳು ಗುರುತಿಸಬಹುದಾಗಿದೆ. ಇಂತಹ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ವಾಹನಗಳ ಎದುರಿಗೆ ಸುಮಾರು 100 ಮೀಟರ್ ದೂರದ ಅಂತರದಲ್ಲಿ ದೊಡ್ಡ ನಸುಕಿನ ವಾಹನವೊಂದು ಬರುತ್ತಿದ್ದನ್ನು ಗಮನಿಸಿ ವಾಹನದ ಸಂಖ್ಯೆ ನಮ್ಮ ಇಮೇಲ್ ಬಿಲ್ ಪೋರ್ಟಲ್ ನಲ್ಲಿ ಪರೀಕ್ಷಿಸಿ ಉದ್ದೇಶದಿಂದ ಇನ್ನೂ ಸ್ವಲ್ಪ ಹತ್ತಿರ ಉದ್ದೇಶದಿಂದ ನಮ್ಮ ವಾಹನವನ್ನು ಸ್ವಲ್ಪ ಮುಂದಕ್ಕೆ ಚಲಾಯಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದಾಗ ನಮ್ಮ ಮುಂದೆ ಬರುತ್ತಿದ್ದ ಸುಮಾರು 24ರಿಂದ 25 ಟನ್ ತೂಕದ ವಾಹನವು ನಮ್ಮ ಕಡೆಗೆ ಅಂದರೆ ಬೈಪಾಸ್ ರಸ್ತೆ ಕಡೆಗೆ ಬಂದು ಸರ್ಕಾರಿ ಇಲಾಖೆ ವಾಹನವೆಂದು ಗೊತ್ತಾಗುತ್ತಿದ್ದ ಹಾಗೆಯೇ ವಾಹನ ಚಾಲಕನನ್ನು ತಕ್ಷಣವೇ ಪಕ್ಕದಲ್ಲಿ ಕಂಡು ಬಂದು ಒಂದು ಸಣ್ಣ ರಸ್ತೆಯ ತಿರುವಿನಲ್ಲಿ ತಿರುಗಿಸಿ ಜೋರಾಗಿ ಬದಲಾಯಿಸಿಕೊಂಡು ಹೋಗಲು ಪ್ರಾರಂಭಿಸಿದ್ದನು. ಆದ್ದರಿಂದ ಸಮಯಕ್ಕೆ ಆ ವಾಹನ ಚಾಲಕನ ಕಡೆ ನಡೆ ಅನುಸ್ಪದವಾಗಿ ಕಂಡು ಬಂದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಈ ವಾಹನವನ್ನು ಹಿಂಬಾಲಿಸಿಕೊಂಡು ಹೋಗುತ್ತಾ ಚಾಲಕನಿಗೆ ಟಾರ್ಚ್ ಬಿಟ್ಟು ನಿಲ್ಲಿಸಲು ತಿಳಿಸಿದರು. ಸರಕಿನ ವಾಹನವನ್ನು ನಿಲ್ಲಿಸದೆ ಸುಮಾರು 3 ಕಿಲೋಮೀಟರ್ ಮುಂದೆ ಚಲಾಯಿಸಿಕೊಂಡು ಹೋಗಿದ್ದರು. ಈ ರಸ್ತೆಯ ಸಾಲುಗಳ ಪಕ್ಕದಲ್ಲಿ
ವಾಸಸ್ಥಳ ಮತ್ತು
ಚಿಕ್ಕ ಚಿಕ್ಕ ಅಂಗಡಿಗಳನ್ನೊಳಗೊಂಡ ಸುಮಾರು 10ರಿಂದ 12 ಅಂಗಡಿಗಳು ಅಗಲವಾಗಿ ನೀನ್ ಕರೆಕ್ಟ್ ಆಗಿರೋದು ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ನನಗೆ ಓದಿರೋದು ಕೂಡ ಕಿರಿದಾದ ರಸ್ತೆಯಾಗಿದ್ದು ಸಣ್ಣ ಪುಟ್ಟ ವಾಹನಗಳು ಮಾತ್ರ ಸರಾಗವಾಗಿ ಸಂಚರಿಸಬೇಕಾಗುತ್ತದೆ ವಿನಃ ಈ ರೀತಿ ಸರಕು ತುಂಬುವ ಭಾರಿ ವಾಹನಗಳು ಸಂಚರಿಸುವ ರಸ್ತೆ ಆಗಿರುವುದಿಲ್ಲ ಹಾಗೂ ಎರಡು ಕಡೆ ವಾಹನಗಳನ್ನು ಒಟ್ಟಾಗಿ ಸಾಗುವಂತಿಲ್ಲ. ಸದರಿ ವಾಹನ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದಾಗ ಎಲೆಕ್ಟ್ರಿಕ್ ವೈರ್ಗಳ ಭಾರಿ ಸರಕಿನ ವಾಹನಕ್ಕೆ ತಾಗಿ ತಡೆದಿದ್ದರಿಂದ ವಾಹನವನ್ನು ಮುಂದೆ ಹೋಗಲಾಗದೆ ನಿಲ್ಲಿಸಿ ನಿಂತಿತು. This is the attitude. And in next paragraph ಅಲ್ಲಿ ಭಾರಿ ಸರಕು maybe this sounds like a script in some serial or an episode which comes on OTT. Pushpa movie.
Bigger than Pushpa and Bahubali, my lords.
ಭಾರಿ ಸರಕು ವಾಹನ ಮೇಲಿನ ಟಾರ್ಪಲ್ಗಳು ಎಲೆಕ್ಟ್ರಿಕ್ ವೈರ್ಗಳಿಗೆ ಅಡ್ಡಲಾಗಿ ಸಿಕ್ಕಿ ಹಾಕಿಕೊಂಡು ಸರಕಿನ ವಾಹನ ಸಮೇತ ಸುಟ್ಟು ಹೋಗುವ ಸಂಭವ ಇದ್ದುದರಿಂದ ಈ ಸಣ್ಣ ಜಾಗದ ಸುತ್ತದಲ್ಲಿ ಇದ್ದು ಅವರು ಓಡಿ ಹೋಗಿ ಬಂದು ಸರಕು ವಾಹನವನ್ನು ಕುಳಿತಿದ್ದ ಚಾಲಕನನ್ನು ಸೇರಿ 3 ಹುಡುಗರನ್ನು ವಾಹನದಿಂದ ಕೆಳಗೆ ಇಳಿಸಿ ವಾಹನವನ್ನು ಸರಕಿನ ಅಡ್ಡಲಾಗಿ ಸಿಕ್ಕಿ ಇಟ್ಸ್ a public there who have caught them and given it to us. This is the reason why my lords have been insisting on the Sarakana traders. They are into this practice. If I may say so, my lords, with respect, it is very difficult for the field officers to work in certain places, especially during the night times.
Lords, with
I'm given to even make a submission saying that, my lords, when 6 to 8 lorries go at a time, there is a Scorpio which goes behind with the printer and laptop. The moment it is caught, the documents are generated and given it to the driver. Anyway, these are all not on record. But this is the behavior, my lords. What can I do taking a security from him, my lords?
My lords, in this case, there in respect to that show cause notice, there are many inconsistencies, man.
Let us see.
My lords have already seen.
Let us
The moment
I
they
have
saw, they
not gone
figured out
into-
it's 24,
My lords,
25 tons, my lords.
Entirely documents are not there. I have not gone into the merits of the matter. I am just only citing, my lords, the way the system is working.
Silence is your argument.
No, my lords,
No, I'm saying silence, it's better to be silent now.
Yes, sir.
Let us see.
I'll stop it at my lords. This is the attitude. This is the behavior of the petitioner. And what can I do with an security from him, my lords? And if I go back to the transport, probably he'll be one of the same transporters who's involved in the other things also.
The petitioner submits that this court had passed an
And
order.
luckily, the transporter's name is Surakshit Transport. ಇಷ್ಟು ಸುರಕ್ಷಿತವಾಗಿ ಗಾಡಿ ತಗೊಂಡು ಹೋಗ್ತಾರೆ.
The counsel for the petitioner submits that this court by order dated 22/1/2026 had granted an interim order for release of goods.
Yes, goods and yes, my lords, vehicle and goods.
Goods. And till date, in light of dispute regarding furnishing of adequate security as directed, goods have not been released. Petitioner makes an oral request for release of goods and vehicles upon terms that may be fixed, which petitioner is ready to abide without insisting upon furnishing of security.
And I'm sorry, Manoj. Why we have rejected the security that they have furnished, Manoj? I have got documents. They have furnished a security of 3 guntas of land in a rural area. Manoj, we have sent it for valuation to the Tashildar. Tashildar writes back, it values only so much. And they want us to take the market value. We cannot take them. We can only take the guidance value, Manoj. That is what is prescribed by.
Let us see. After hearing the matter for some time and noticing that this court in other matters wherein challenges have been made to the order of confiscation under section 130 of the Act has been directing release of goods and conveyance on payment of 25% of the value as made out in the order at under section 130, with further direction to furnish indemnity bond regarding value of goods for the remaining 75% of the value as mentioned in the order. It would be appropriate on same terms as well to direct release of goods and conveyance. Now this valuation is of goods and conveyance.
Yes, my lords. That can be seen at page number 59.
No, I'm just asking.
Yes, my lords, as per their valuation.
The petitioner has filed memo of calculation. Same is taken on record. It is submitted by the petitioner that the valuation of 25% would be in terms of the memo of calculation. Next, in modification of the earlier order of 22/1/2026. There would be an order directing release of goods and conveyance subject to petitioner paying 25% of the total valuation as made out in the order under section 130, full stop. Remaining 75% of the valuation to be secured by way of an indemnity bond. Petitioner to also file an affidavit with an undertaking that they would diligently pursue the present proceedings to its logical end and abide by orders to be passed. Full stop. Needless to state, in the event of any action by the petitioner inconsistent with the undertaking in the affidavit, petitioner would expose himself for action under the Contempt of Courts Act. Full stop. Accordingly, the revenue is directed to release the vehicle in terms of the above direction. 5% of valuation as per section 130 to be paid and the remaining to be secured by indemnity bond terms of the observation made above.
Can it be noted that I've already deposited 10 lakhs and only the balance had to be?
The 25% to be paid would include, would be quantified by taking note of 10 lakhs already stated to have been paid, and the obligation of the petitioner would be for the remaining amount.
Yes, ma'am. And my lords may also note that I've already paid that another 3 lakhs also by discharged by pay of my GSTR 3B. So totally I've paid 13 lakhs. In that memo of calculation I've already written, my lords. In that
13 lakhs and that. 13 lakhs, 30.
GSTR 3B will be something that is along with the return. Don't mix up things. Again, you will get into problem.
I'll deposit 9 lakhs, my lord. My lords, I've already furnished an indemnity bond, my lords.
10 lakhs.
That may be taken note. I've already
The
furnished.
respondent authority to proceed further, taking note of the observation made in this order.
Only 10 lakhs.
Yes, yes.
And whatever the documents I've submitted, let it be returned, my lords.
Needless to state, the respondent authority may return documents furnished as security in terms of the directions of this court in its earlier order dated 22/1/26.
Deeply obliged, my lord.
My friend is interested in coming back again for a clarification before this court. He wants to, along with the return, what is fine, he wants to.
I'll deposit the entire amount.
Yes, the client,
Deeply obliged.
don't blame him, the client. Yes. Next court.
Right.
81. 81. This is the same item, Malats, where I mentioned in the morning. There's an interim order, Malats, operating in my favor. Malats, I've 96. The interim order, Malats, is dated 21st March 2025. My apprehension is, Malats, I am in litigation with respondent number 6.
What is the interim order?
Malats, the interim order is that, Malats, the entitlement may take my lords to the third page.
Page 3.
Page 3 of the interim order.
Stay of the order at Annexure T.
Yes, Malats, the Annexure T was the entitlement order where the concerned person was asked to come and collect the compensation.
Now, what is the apprehension?
Malats, they have issued letters, to best of my understanding and knowledge, Malats, that to respondent number 6 to come and collect the compensation. Morning, Malats, Krishna sir made a statement that we have not done such thing, that if that thing can be recorded, Malats, my apprehension for now, this week it will be sorted.
The entitlement certificate we issued before the filing the, after my interim order, we have not dispersed the compensation to anybody. It is still with
The counsel for the petitioner moved the matter for being taken out of turn on the ground that there was a possibility of the respondent BDA dispersing the compensation amount to the sixth respondent. Despite interim order passed by this court on 21/3/25. Land Counsel Shri K. Krishna submits that
On
after
instruction.
upon instructions of the concerned officials that after the order of 21/3/2025, they do not intend to disperse compensation till the present petition is disposed of. Said statement is taken on record. Relist week after next.
That's there's office objection that copies have not been served. I filed an IA for amendment. That's copies have been served on respondent number 6. That's I'll serve another copy on then physical copy also. That may be dispensed. It can come in a regular course merge for the consideration of an IA. The other aspect, that's acknowledgements.
What is IA 1 of 26?
That's IA 1 of 26. I'm seeking for some amendments. That's in the
list. Week after next on IA 1 of 2026.
That's next week I can get.
Next week. Yes.
Grateful.
My lord, in this matter,
yes,
Hem Kumar has taken notice already.
Hem Kumar. Hem Kumar.
My lord, in this matter, respondent number 1
Yes.
My lord, in this matter, respondent number 1 is the same person who did the audit, issued the show cause notice and passed the order, my lord. I have other grounds as well, but I would like to make a submission that merely because I'm a state tax SSC, the administrative safeguard given to a central tax SSC, I am not getting that benefit. Because of this, there's a treatment of there's a differential treatment between a state tax SSC and a central tax SSC. Because in the central tax SSC, my lord, there's an administrative safeguard saying that the person who has done the audit cannot do the adjudication and pass the order. Merely because I'm a state tax SSC, I am not given the safeguard. That is my submission on this particular point, on the jurisdiction point, my lord. I have other questions. I have other grounds on merits as well. My lord, respondent number 3, that's the appellate authority, is this did not consider the additional evidences which I have submitted during the appellate procedure. In page number 40, my lord, he records that appellant company has submitted additional submissions, which is perused in detail. It is in page number 40, my lord, the first line.
Yes.
And further in the next paragraph, the last line, he mentions that now the copies of invoices are submitted in support of the input tax credit. My lord, basically the input tax credit was not given because certain original invoices were not giving. That certain original invoices were not given during the audit time. Whereas in page number 107, my lord, this is my submission before the appellate authority in para number 9.
Yes.
Page 107, para number 9. I have mentioned that appellant wishes to submit that the moot issue in observation number 1 is that the denial of the ITC of 8.38 lakhs for so and so period for the reasons that the original tax invoices are not submitted. Further, my lord, in point number 10, I mentioned that I wish to submit the entire of the invoices on which I have availed ITC. My lord, first point being that the ITC was not provided because the original tax invoices were not given. However, the appellate authority, without considering, without giving any finding that the original tax invoices are correct or not, he mechanically dismisses the ground. Further, in page number 44, my lord.
This is in the nature of an appeal, is it?
In the nature of an appeal, my lord. After the appeal, I have come here.
No, correct, there's a second appeal.
Second appeal, because the GST it is not yet.
So we'll entertain it then if it's second appeal.
My lord, I'm also on this jurisdiction point that.
No, let us see, let us
Yes,
see.
yes,
That
ma'am.
matter we are hearing in one of the matters.
Yes, my lord.
We'll see.
Yes, my
But
lord.
with
My
no-
my lords are asking them to deposit 10% additional tax.
My lord,
Then
I have,
staying the recovery proceedings.
my lord, I've already deposited 10% when I have come to the appeal
That
procedure.
is the first appeal.
Yes, my lord. But however, since there is a jurisdiction issue as well, if my lord may consider.
You pay it, we'll see. The rest is it will inure to your benefit if it's set aside.
Yes, my lord, but since this particular point on jurisdiction point,
No, that we'll see. That's okay. No, you deposit 10% of the.
because this matter of jurisdiction is pending before the courts,
You
if,
find
if,
out.
if my lord may consider.
You find out, you find out. I'll have it on Tuesday if you want.
My
You find
lord,
out.
I'll make the 10% payment, my lord, but kindly an interim protection may be provided because.
The petitioner has raised various contentions assailing the order in original as well as order passed by the appellate authority. It is submitted that the appellate authority has not taken note of the statement of the petitioner that the invoices with respect to which would evidence petitioners having made supplies and having availed ITC, though produced and as referred to by the appellate authority in para 10 of the order, has not been considered. Matter requires consideration in the interregnum. There would be stay of
Annexures A to D, my lord.
annexure A to D. Petitioner to make deposit of 10% of demand.
10% of the tax amount in addition to what is already
10% of the tax
My lord, may kindly,
which would be apart from what has been
already deposited.
already deposited at the time of the first appeal.
First appeal.
Yes, Him Kumar accepts notice for the respondents.
My lord, 3 weeks time might be granted for making the deposit, my lord.
Petitioner undertakes to pay the tax as directed within a period of 3 weeks from today.
Grateful, my lord.
Yes.
Lords, BDA has issued annexure F, my lord, with regard to the, since 1960s, my lord, my erstwhile husband has built the house by rehabilitation. Construction was taken place. In meanwhile, my lord, after a lapse of 6 decades, in 2017, my lord, respondent number 4 claims that he has got executed the sale deed by the BDA based on some condition from his erstwhile father. My lord, subsequently, my lord, they have issued the notice under section 41A of the Karnataka Premises Act, my lord, which there doesn't have any local standing. Since they themselves have claimed that they have executed sale deed in favor of respondent number 4, how could they will issue notice under the public premises, my lord? It is the respondent number 4, it is his lookout to file eviction suit and he should take necessary action, my lord. And they cannot get all of them some six decades, my lord.
What is this?
The petitioner site is allotted to the third respondent.
Fourth respondent.
Fourth respondent.
2017.
2017. Is a
what is the
petitioner is
relation?
unauthorized occupant.
Since 1960, I am staying, my lord.
No. What is your relationship with the fourth respondent?
Fourth respondent, my lord. I don't know, my lord. He claims to be a reservation. I am also claims to be a reservation.
I'm saying allotment is done to whom?
Respondent number 4. That's Kempaya, my lord.
Kemparaju.
Sorry, my lord. Kemparaju. He also claims to be reservation. I am also claims to be reservation.
No, just one. Now, allotment is made to the fourth respondent.
Fourth respondent.
And the petitioner is residing in
Residing.
That. It's a plot, is it?
Yes, dwelling house, my lord. It's a dwelling house.
Site,
20 of 25.
Site.
Site. You have allotted to the fourth respondent.
Fourth respondent.
Now, according to you, he's in unauthorized occupation.
Unauthorized.
Petitioner is unauthorized. Without any holding an inquiry, my lord, how they will execute a sale deed, my lord?
He filed suit for injunction. It was dismissed.
Against respondent number 4, not against BDM, my lord.
My lord, now the Public Premises Act, we have taken the steps, my lord. Let them to file the objection before for the notice before.
We have already submitted, my lord. Kindly see page, my lord. They have also issued endorsement on that aspect also, my lord. We have made a representation.
This is the order of injunction.
My lord, in annexure E, my lord, they have given a representation for regularization.
Where is the order of injunction?
Rejection, my lord, not on this thing, my lord. We have submitted. I have not submitted.
F, my lord,
Annexure F.
Page 34, my lord. 39, sorry, 39.
But they have not given any endorsement on this aspect, my lord. They have only given a.
Please listen.
Yes,
I want to know.
Notice was issued.
Some suit, it appears some suit was.
Yes, yes, I have mentioned all this aspect, my lord.
Do you have a copy of
Copy have not been filed, my lord. But I have narrated all the facts, my lord. I have not.
Let them to produce all the documents and file the reply to this notice, my lord. It is under Public Premises 4-1 notice. Thereafter, my lord, he will.
But my question.
Thereafter, my lord, competent authority hear them and then pass the order, my lord. It is only notice.
No, correct. According to you.
Yes.
Though it was allotted to the fourth respondent.
Yes.
He has entered into possession and.
No.
He's unauthorized, constructed in the building in that site, allotted site. Therefore, my lord, in the Public Premises Act, we have issued the notice to evict, to vacate that and hand over them. Now let them to file the documents. If we add the titles and produce the documents and file the reply. Then, my lord, after hearing, my lord, we will pass order under section 5(1) of the Act. The remedy is, my lord.
Now the encroachment by him
Yes.
was earlier to allotment to the.
Yes, my lord.
According to him.
Kindly see page, annexure B, my lord. Kindly see page 21.
According to him, he is in position earlier to that. But this site was allotted to the fourth respondent and sale deed was also executed in his favor of the fourth respondent.
So you are saying that he had illegally occupied the property.
If it is, even if it is assumed that he is occupied the property earlier to, then.
No, just 1 minute. Only if it is earlier, you will have jurisdiction.
Yes.
You will have, if he has taken the stand that is in possession earlier,
yes,
then you may have jurisdiction.
Yes.
If after execution of sale deed, then it's a private dispute.
Yes, that is correct. But here he admitted that he is prior to the. Prior to the notice.
Okay, you place, now before initiating this annexure F,
yes,
you would have some note sheet, whatever. You place it on record, we'll see.
Yes.
I'm not staying it though,
yes,
but I'll have it next week. You place material in support of it.
Yes.
You will have to prima facie show that this encroachment was prior in
prior
point
to
of
the.
My lord,
otherwise you have no jurisdiction.
Yes.
My lord, let them submit on what basis the sale deed was executed.
No,
Those conditions, my lord.
That we can't enter into in the present case.
My lords, may I just point out one aspect, just one document.
No, let us see.
Just one document.
Let us see. I'll have it next week. Let them produce. We'll see what is.
Just one document I just wanted to point out, my lord. Kindly see page 21 for a moment, my lord. I raised the loan and constructed it. My lord, kindly see page 21, my lord, annexure B. I was a Goller and my lord in the Treasury Department, my lord. In 1960, my lord, I raised a loan from the.
Maybe raise the loan, my lord.
1960s is the from the occupation, my lord. From 1960, my lord, kindly see page one more, my lord. Still now, my lord, the electric supply and water connection is also standing in my husband name. Kindly see, my lord, page 23 D1, my lord.
Let us see. No, but you will have to examine whether after 30-40 years you can initiate proceedings. Relist next.
It's only 10 years, there's a condition, my lord. Only 10 years. Based on that, they have executed a sale deed.
Let us see. Relist next week. Date.
My lord, all that I'm seeking only into limited aspect, my lord. They are daily, my lord. They are coming and issuing threatening notice, and they have affixed the notice on my when I am not in possession, my lord. In my native, my lord. They have came and they have affixed the notice on my in possession of the wall on the, my lord.
4-1 notice was issued. It was affixed. 4-1 notice.
Earlier they have issued notice. That also have been enclosed, my lord. Earlier notice also enclosed, my lord.
File the objection.
Let us see. Let us see.
Earlier also they have issued notice, that is also been enclosed, my lord.
See on the next week, relist on date 16.
Great.
Lord, appearing for the petitioners in this. First. On last date, we have filed written arguments, my lord. The respondents has to revert back.
Tomorrow, relist tomorrow.
Great.
Manjuna. Yes.
This matter, my lord, may request for a adjournment till Friday, my lord. We have mentioned it. We have mentioned it in the morning. I've been instructed, my lord, either he'll come tomorrow as a mentioning list or on a Friday. If any chance, my lord, if I'm unable to address my argument on Friday, I will file my written argument.
Right. Now I will accommodate you.
Yes.
But you argue. I will not proceed to passing of orders. I will not proceed to passing. I will accommodate 1 day, 2 day. That's okay. We will accommodate you. But what is your stand? You at least you argue. We'll see. Now, insofar as you are, we will accommodate you. That's not an issue.
There's some
But
confusion.
what is your argument? We want. I'm curious to know what is your argument.
Please, Friday.
No, that I'll give you time. But if you finish your argument, I'll accommodate you.
Not even prepared for that.
Huh? There's nothing.
No, there is argument. I am supported by coordinate bench of this judge.
No,
this
your
honorable court.
contention. Let us see.
I'll face the judgment also.
We'll test. I want to test. Now, your contention is once the order was passed.
Correct.
Of extending time, when the proceedings were still not set aside, that order can still stand till its expiry. That's what you are saying.
That is one argument.
One argument.
The best argument of my argument. Of course, that may not survive in view of two judgments of Bombay High Court. That argument may not survive. My lord. I'll say it now. The other argument, my lord, is that the charge sheet has been filed, and it is not a default in the sense of default where we find a 167.
Notes. No, but you must remember, no doubt, on filing of the charge sheet, the right to default bail stands extinguished, provided till then they are not exercised their
Correct.
right. Now here, admittedly, they had filed their application in the morning session.
Correct.
And you filed your in the afternoon session.
Correct.
In terms of Kapil Wadhwan, that position also has been explained, saying that whichever, if you file it prior in point, later in point of time, then it can't be considered.
The Kapil Wadhwan, their best argument is Kapil Wadhwan. In fact, I'll distinguish how Kapil Wadhwan has no application in the present case. That I have to distinguish, my lord, that the coordinate bench judgment of this court and also the interpretation of section 22 of COCA or 23 of MOCOCA, which deals with these scenarios. There is no judgment directly related to same issues where sanction has been set aside, permission has been set aside, subsequently application was moved.
But I think that the Bombay High Court judgment,
which
says the default argument is, let's even without dating it back, suppose it is set aside today, then it would be reasonable that tomorrow,
correct,
you should file the charge sheet.
Correct.
Now, if we were to take it like that, here you have filed after some 3-4 days, I think, isn't it?
So both of us have filed on the same day.
Same day.
Same day.
So they are in prior in point of time. The only argument that you are saying is there are practical difficulties, and by the sudden collapse of setting aside, it would not be practicable to insist on filing.
In Kapil Vadvan, my lord, the whole debate was to count the day of remand or the next day. Supreme Court said you will have to count the day of remand itself, not from the next day. Therefore, you lost your right. And since they have filed it in advance, they are entitled for it, is what Supreme Court said it. My argument, my lord, whether it is not that the rights, it is not that I am waiting for that your lordship to pass an order or wait for the time to lapse. I was conducting investigation. I have conducted investigation with respect to two accused. There are orders passed by one by this court, one by trial court, in taking into custody of taking to police custody. Therefore, our investigation could not be completed. There is no point in filing a charge sheet against some accused people and wait for some other accused people, waiting for this court to pass an order or trial court to pass an order. Therefore, we had a legal time to file a charge sheet, and we were waiting for that period. So far, with respect to the other accused people, though investigation was largely completed, and we did not file it because waiting for others and then file a comprehensive charge sheet. So that could not happen, and then we had no option. Then we filed a charge sheet. Now the only issue is, since they have filed an application at 11 o'clock, 11:30 or 12:30, whatever, and I have filed an application at 5:30, their application is first. In fact, Kapil Vadvan, though, records the time in which the application was filed and the charge sheet was filed. But your lordship has to, I'll demonstrate, my lord, how Kapil Vadvan has no application in this case, because the lapse on the investigation officer to understand whether the first day or second day. Here is, we are not dealing with that case. Here is the case. I was in a bona fide belief that the action which I have done is legally right. Of course, your lordship has held it is not legally right, and we have taken to Supreme Court. Supreme Court also expressed it, whatever it is, but Supreme Court said that should not be applied as a principle, as a precedent. So that is what we sought for a clarification. Once the clarification comes, if it comes in my favor, I say.
Right, but now there are two things. In case of any ambiguity, I think in Jigar's case, there is some observation. It would always be in favor of the accused.
That also correct, my lord.
Yes, one. Two, now the Supreme Court has not stayed it.
Correct.
It has said it would not be a precedent in other matters. Till the matter is decided, as on date, the order would operate.
No.
And insofar as this point of morning and thing, we will have to take a call, either accepting now even Bombay High Court says next day. Next day, no doubt it says next day, but the time, if they are earlier in point of time, now we have to determine. Now
the division bench judgment of this Honorable High Court dealt with the time also. Dealt with the time, whether application filed by default bail application filed by them, subsequently filed by us. This court has said that it has to be considered together. That's the judgment I will have to rely on. That's the only judgment so far I'm relying on. And also to elaborate what is the default in a sense of default mentioned 167 versus the scenario which we are in. I will make my attempt on those two grounds. Only my request, my lord, lordship may accommodate me till Friday. If I am not able to be present in the court on that day, and I will file my written argument, your lordship may take it. I'm not going to ask more time than Friday.
Okay. In case tomorrow, anyhow you are there for other matters.
Yes.
You argue tomorrow, I will accommodate.
Hello.
Deal is tomorrow. What is the division bench you are relying on? Which order of the division bench?
Division bench, Justice Harish Kumar and Justice Vijay Kumar Patil. That's the judgment which dealt with that issue.
That says that you have to?
Together, has to be considered together. Though they have filed an application in advance and we have filed a charge, our action is later, done on the same day. They said it has to be, because it dealt with an issue of extension of time and other things. And I will place the judgment.
Tomorrow?
Yes.
Yes.
Relying on Kapil Vadwani, and Kapil Vadwani only deals with the day when you commence calculating. That should be the day of remand. But that is just not what the judgment deals with. It also deals with if the application is filed earlier in point of time, your indefeasible right becomes absolute. Other than Kapil Vadwani, my lords, in Ravindran's case itself, 3-judge bench, kindly notice these paragraphs, my lords. I think that will settle the issue with saying Well, it's three-judge bench, and this was authored by His Lordship Justice Mohan Shantargowdar, 2021 2 SCC 485. Well, it's one is the aspect they deal is that it amounts to an illegal custody. After that date, if they're still inside, my lords, it amounts to an illegal custody, which my lords should notice at paragraph 18.7. Page 509, my lords. 509. Please notice 4 lines from the top. This could not have been the intention of the legislature. My lords, gets that portion, my lords. 18.7 on the next page, page 509, my lords. 4 lines from the top. This could not be the intention of the legislature. That portion, my lords, gets. If such a practice is permitted, the same would amount to deeming illegal custody as legal, because after that period is over and you file your application, post that the custody is illegal, my lords. That is what they observe in that. After the expiry of the stipulated period, the court has no further jurisdiction to remand the accused to custody. Prosecution will not be allowed to take advantage of its own default of not filing the investigation or report against the appellant within the stipulated period. Then paragraph 23 may be noticed, my lords.
Now, what is this remand?
My lords, every 15 days, the remand that takes place by the magistrate to judicial custody. But as soon as, my lords, it is noticed that that 90 days period is over or the extended 180 days period is over, the charge sheet is not filed and the application for default bail is filed. As soon as the application of default bail is filed, thereafter, my lords, there can't be any remand done because it amounts to illegality.
Para 20.
Paragraph 18.7, then paragraph 23, my lords. Because even in Ravindran's case, my lords, what happened is on the very same day that the default bail was filed, in the evening, my lords, they filed additional complaint. So court said if you have filed it after the application for bail on the same day also, the right has become absolute. Similar to what we got in ED versus Kapil Wadhwani on the same day. Even in Ravindran's case, it was on the same day. So my lords, paragraph 23 at page 517. At the cost of repetition, it must be emphasized that the paramount consideration of the legislature while enacting 167(2) and the proviso thereto was that the investigation must be completed expeditiously and that the accused should not be detained for an unreasonable long period, as was the situation prevailing under the 1898 code. This should be in consonance with the obligation cast upon the state under Article 21 to follow a fair, just and reasonable procedure prior to depriving any person of his personal liberty. Now, conclusion, my lords. In the present case, admittedly, the appellant had exercised his option to obtain bail by filing the application at 10:30 a.m. on the 181st day of his arrest, that is immediately after the court opened on 1/2/2019. It is not in dispute that the public prosecutor had not filed any application seeking extension of time to investigate into the crime prior to 31/1/2019 and prior to 10:30 a.m. on 1/2/2019. The public prosecutor participated in the arguments of the bail application till 4:25 p.m. on the day it was filed. It was only thereafter that the additional complaint came to be lodged against the appellant. Therefore, applying the aforesaid principles, the appellant accused was deemed to have availed of his indefeasible right to bail the moment he filed an application for being released on bail and offered to abide by the terms and conditions of the bail order at 10:30 a.m. on 1/2/2019. He was entitled to be released on bail, notwithstanding the subsequent filing of an additional complaint. It is clear that in the case on hand, the state investigating agency had, in order to defeat the indefeasible right of the accused to be released on bail, filed an additional complaint before the court concerned subsequent to the conclusion of the argument of the appellant on the bail application. If such a practice is allowed, the right under 167(2) would be rendered nugatory as the investigating officers could drag their heels till the time the accused exercises his right and conveniently file an additional complaint, including the name of accused, as soon as the application for bail is taken up for disposal. Such complaint may be on flimsy grounds or motivated merely to keep the accused detained in custody, though we restrain from commenting on the merits of the additional complaint in the present case. Irrespective of the seriousness of the offence and the reliability of the evidence available, filing additional complaint merely to circumvent the application for default bail, in our view, an improper strategy. Hence, in our considered opinion, High Court was not justified in setting aside the judgment and order of the trial court, releasing the accused on default bail. Then, my lords, 25 may be noticed in conclusion. This is how they would notice it, my lords. Therefore, in conclusion, 25.1, once the accused files an application for bail under the proviso to 167(2), he is deemed to have availed of or enforced his right to be released on default bail, accruing after the expiry of the stipulated time limit for investigation. Thus, if the accused applies for bail under 167(2) CRPC read with 36A of the NDPS upon expiry of 180 days or the extended period as the case may be, the court must release him on bail forthwith without any unnecessary delay after getting necessary information from the public prosecutor as mentioned supra. Such prompt action will restrict the prosecution from frustrating the legislative mandate to release the accused on bail in case of default by the investigating agency. The right to be released on default bail continues to remain enforceable if the accused has applied for such bail, notwithstanding pendency of the bail application or subsequent filing of the charge sheet or a report seeking extension of time by the prosecutor before the court or filing of the charge sheet during the interregnum when challenge to the rejection of the bail application is pending before the higher court. However, when an accused fails to apply for default bail, when the right accrues to him and subsequently a charge sheet, additional complaint or a report seeking extension of time is preferred before the magistrate, the right to default bail would be extinguished. The magistrate would be at liberty to take cognizance of the case and grant further time for completion of the investigation as the case may be, though the accused may still be released on bail under other provisions. Notwithstanding the order of default bail, rest of it may not be relevant. Now, my lords, in our case, 22nd, when we filed the default bail, my lords, the rejection of the default bail took place on 26th. 26/12, the magistrate rejected it, my lords. We would approach the sessions court after that in revision. Now, when is it that the SLP was filed? The SLP, my lords, was filed on 27/12/2025 after the magistrate court had rejected my default bail. And in the SLP, my lords, they would seek an interim order of stay.
SLP was filed
on 27/12/2025.
The magistrate rejected
Had rejected our default bail on 26/12/2025. So, my lords, they would anticipate that the default bail will be sought for, and when they sought for stay of the order passed by this honorable court, that was the specific reason given. My lords, in paragraph 6 at page 54, in their grounds for interim relief, my lords, I'll just read this ground, my lords, my lords, ground for interim relief, asking for stay. It is further submitted that the other accused involved in this case may seek default bail since the requirement to file the charge sheet in this case was within 180 days, and if COCA order is set aside by the Honorable High Court, the other accused may seek default bail and therefore stay the proceedings. Specifically, they say that is the reason given, and the prayer for interim is stay of the order passed by this Honorable Court. Matter comes up for consideration, my lords, on 10/1/2026 for the consideration even of this stay which they have sought for. 10/1/2026
before the apex court.
Before the apex court. And apex court, my lords, does not stay the order passed by this court. All that the apex court says is it cannot be used as a precedent elsewhere. Then when we have commenced argument in our case now, my lords, Now an application that is being filed in Supreme Court, one is for advancement, two is asking for the very stay. And the reasons they're asking for stay is this honorable court is considering the default bill. The situation is no different than what it was when the SLP was filed to what it is now. So seeking time on the ground that we have moved the Supreme Court seeking stay, my lords, my respectful submission, especially in a case where the custody is illegal post that period, my lords. That may not be valid, my lords. We can't wait for the outcome of what is going to happen there. So, yes, my lords.
For petitioner. In this case, there is a direction to produce the records from the KDB. Since my lord, I have challenged my lord the procedure followed in acquisition.
Is KDB who appears? Huh?
Either records ತಂದಿದ್ದಾರೆ. I was told that not is brought the records today.
You have. You have a look at it, no? Whatever.
Allah, if you permits me, I will verify.
You
I
ask
can,
him.
without seeking permission, but I cannot.
I'm giving permission, but you ask him. And
Please.
We'll have it tomorrow.
Please, ma'am, please.
Relist tomorrow.
2:30, my lord.
Yes. There is no.
Kindly, my lord. Serial number 34, my lord. Serial number 7. Serial number.
Matters.
Your lordship.
Serial number 87.
Huh?
My lord, serial number 75.
34, my lord. Your
Tomorrow
lordship.
morning at the top of the list, sir.
Morning.
Because
Let us see.
Serial number 34, my lord.
Item number 73, my lord, consolidated notice, stay was issued earlier. For the
Correct.
subsequent
No.
period, they are proceeding.
Matters will
Lordship,
be.
serial number 87.
Serial number 34, my lord.
May be posted tomorrow. It's an ex-parte order. It has
Fresh
to be
matters,
posted.
fresh matters from yesterday, my lords, have been repeated today because they have not been taken up for stay for consideration. It can be taken up tomorrow, my lords.
Fresh matters.
Serial number 34, my lord.
Fresh matters which have not reached and no interim orders passed. It will be repeated tomorrow.
Serial number 34.
Please mention the numbers.
Serial number 34, my lord. Day after tomorrow, at least, my lord. Serial number.
my
Serial-
lord, my lord, there is a
Serial number 34, my lord.
there is a adjudication.
KDB has released the amount, my lord, despite the orders of this honorable court. Lord, that was what your lordship said. 74, my lord, that is there.
Serial number 34, my lord. Day after tomorrow.
My lord, there is a adjudication
Serial-
order hanging on me. Tomorrow morning.
Mr. Patiwala.
Serial.
Yes.
Serial number 34, my lord. Day after tomorrow, my lord. Friday.
Let us.
Serial number.
Your lordship.
Those things.
Serial number 34, my lord.
Those matters that can't wait till next week to make a request, we'll see. Tomorrow is a special bench. Have a separate roster.
Friday, my lord.
No, let us see.
Friday, my lord.
That you ask the court
My lord,
of.
there is
Your
a-
lordship, serial number
Friday.
70.